All rise. The State Court of Milton County is hereby in session with the case of Tristan Carter as representative of the state of Logan Carter, deceased, versus Vicks Vaporium. The Honorable Chief Judge Chris McFadden presiding. State Court of Milton County is hereby in session with the case of Tristan Carter as representative of the state of Logan Carter, deceased, versus Vicks Vaporium. The Honorable Chief Judge Chris McFadden presiding.
Your Honor, you're on mute.
Thank you. Good afternoon. Congratulations to both teams on making it into the final round. If memory serves, I think I've judged both of these teams, and I'm pleased but not surprised to see both of you here. And I'm pleased on behalf of the Court of Appeals of Georgia to welcome you to hold this round virtually in our courtroom. We will defer the introduction of the judging panel, of whom there are 20 odd, until we hold a very long critique at the end of the round. So at this time, I would like to ask the captains of each team to turn their camera and microphone on. I think they are all on. So first I need to ask whether either team wants to record the round and if there's any objection to recording. So captains.
The plaintiff would like to record this round, Your Honor.
Very good.
Aaliyah rapping on behalf of the defendant, Vicks Vaporium. We have no objections to this round being recorded, Your Honor.
Very good. Round may be recorded by both sides. All right, I am now to run through the reminders, which we've all been through many times. Only attorneys involved with the task should have their camera and microphone on. Both attorneys, however, should stay on camera during a witness's testimony. Witnesses should talk to the camera, not the faces on Zoom. Witnesses may not use any written materials, notes, or scripts while testifying. They're supposed to have their statement, but in a folder, and to consult it only when called upon to do so. The Zoom chat is the exclusive province of the timekeepers. So, I'd like to confirm the presence of the timekeepers. Plaintiff side.
Good afternoon. My name is Laura Baikal, and I'll be keeping time on behalf of the plaintiff.
Thank you. Defense?
Yes, Your Honor. My name is Maggie Opsahl, and I will be keeping time on behalf of the defense.
Very good. All right. Now I need to confirm that you've all figured out how to get the screen share to work. Plaintiffs?
Yes, Your Honor. The plaintiff does have a screen share coordinator in court with us today.
Very good. And defense?
Yes, Your Honor. The defense also has a designated screen share coordinator present in court today.
Very good. All right. Next item. And I need to confirm that each side has shared the rosters. Plaintiffs?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. All right, I am now to remind my colleagues, the evaluators, of all the things that we've been told. Well, actually, the first item is to turn cameras on for opening and closing, depending on attorney preference, so we'll get to that in just a moment. Cameras and microphones should be off for witness testimony. Attorneys may stand or sit for presentations and or objections, because that is in large part a function of the technology, the setups they've got. They're free to do whatever works for them. And there is to be no penalty in the evaluation for on that. All right. So, counsel, do you want to have the evaluators visible during the opening statements? You'll notice that there are quite a few of them, so we're up on a two-screen situation at least.
Yes, Your Honor. The plaintiff would prefer to have all the evaluators on screen for all of our speeches.
Very good. And defense, do you agree?
Yes, Your Honor.
So be it. All right then. All right, other preliminary matters. Plaintiff?
Yes, Your Honor. The plaintiff asked that if throughout this trial there are any technical difficulties, that the time be stopped until those difficulties can be resolved.
It will be so. Anything else?
No, Your Honor. With that, after giving introductions, the plaintiff is ready to proceed with the opening statements.
Very good. Defense?
Yes, Your Honor. In pursuant to Rule 42, stipulations are considered already a part of the record. So we reserve the right to cite them at relevant times as needed during the trial, but we ask that they not be read into the record in the interest of time at this moment.
That is also granted. That's how we'll proceed.
Yes, Your Honor.
Anything else?
Yes, Your Honor. We ask that objections under Rule 403 pertaining to prejudicing the jury be held constructively as bench conferences, but held in open court in the interest of education pursuant to Rule 22.
I believe that is correct. And so we'll proceed. There certainly will. There's no mechanism here, or practically speaking, for bench conferences. So that's how we'll proceed.
Yes, Your Honor. And we understand that Your Honor will swear in the witnesses under Rule 16B. And once the witnesses are sworn, the defense is ready to proceed with opening statements.
Very good. Yes, I will do that. See. All right. At this point, as I was reminded, we need to have the teams introduce themselves. So we'll begin with the plaintiffs.
Good afternoon, Your Honor. My name is Hermela Gatacho, and I, along with my co-counsel, Joshua Joseph.
Good afternoon, Your Honor.
And Alia Corey.
Good afternoon, Your Honor.
Represent the plaintiff in today's case, Tristan Carter. I'll ask our witnesses to introduce themselves now as well.
Very good.
Good afternoon. My name is Isabella Dietrich, and I'm Tristan Carter.
Good afternoon. My name is Ladau Gavalda, and I am Devin Andrews.
Good afternoon. My name is Colin Crawford, and I'm Dr. Bill Robinson.
Very good.
Would Your Honor like our timekeeper and our screen share coordinator to introduce themselves as well?
Why don't we go ahead and do that?
Yes, Your Honor.
Good afternoon. My name is Laura Baikal, and I'll be keeping time on behalf of the plaintiff.
Very good.
Good afternoon. My name is Nicole Getz, and I will be screen sharing on behalf of the plaintiff.
Very good. All right, defense.
Your Honor, members of the jury, good afternoon. My name is Ellie Weiner, and I will conduct the direct examination of Kennedy Womack, the cross-examination of Devin Andrews, as well as deliver opening statements on behalf of the defendant, Vix Vaporium.
Good afternoon, Your Honor, members of the jury. I'm Andre Mayette, and I will conduct the direct examination of Joseph Camille and the cross-examination of Tristan Carter.
Your Honor, members of the jury, good afternoon. I'm Aaliyah Rapping, and I will conduct the direct examination of the defendant, Vicky Vavrick, the cross-examination of Dr. Bill Robinson, and I will also make closing arguments on behalf of the defendant, Vix Vaporium.
Good afternoon, Your Honor, members of the jury. My name is Cameron Hardy, and I am Kennedy Womack.
Your Honor, members of the jury, good afternoon. My name is Jonas Löse, and I am Joseph Camille.
Good afternoon, Your Honor, members of the jury. My name is Alana Edwards, and I am Vicky Vavrick.
Your Honor, members of the jury, good afternoon. I am Maggie Opsahl, and I will keep time on behalf of the defense.
Good afternoon, Your Honor, members of the jury. My name is Erin Taylor, and I will be screen sharing on behalf of the defense.
All right. See if there's anything else on my checklist here. All right. Ms. Gottachow, is the plaintiff ready to proceed?
Yes, Your Honor.
Ms. Weiner, is the defense ready to proceed?
Your Honor, after witnesses are sworn in, we'll be ready to proceed.
Very good. All right. I call to order this session of the State Court of Milton County, and I call the case number 21CV-HSMT, Tristan Carter versus Vicks Vaporium. Will all the witnesses please rise? Or raise your right hand. Do you promise that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? If so, answer I do.
I do.
I do.
I do.
Very good. All right. We'll hear opening statements. Ms. Gottachow, you may begin.
Your Honor, it's my
Excuse me, Mr. Joseph, excuse me.
Yes, Your Honor. May it please the court? Opposing counsel, members of the jury, profits over people. Today in court, you're going to hear about a kid. His name was Logan Carter. Logan Carter was an ordinary kid who was on his school's mock trial team and loved to play soccer with his best friend. But one day, Logan Carter's life would be changed forever. At school, he overheard some seniors talking about a vape shop, a store where any fake ID would be accepted. That store is called Vicks Vaporium. After purchasing products from there for a couple of weeks, Logan began to feel sick. He started coughing and having shortness of breath. After a few months, it was revealed that Logan had extensive damage to his heart and lungs. Damage that caused an asthma attack, resulting in his death. Members of the jury, Logan Carter died because the defendant put profits over people. That's why we brought two claims against them in court today: negligence and negligence per se. Now, Judge McFadden will explain these claims to you at the end of the trial, but essentially, to prove negligence, we have to prove four things. First, that the defendant had a duty to keep vape products outside of the hands of minors. Second, that the defendant breached this duty by selling to minors. Third, that as a result in this breach in duty, Logan Carter had an asthma attack that resulted in his death. And fourth, we have to prove that the Carter family suffered because of it. And members of the jury, today in court, you're going to hear that the Carter family suffered because the defendant put profits over people. Now, to prove negligence per se, we have to prove that the defendant violated a public safety statute by selling products to minors. Now, as the plaintiff, we hold the burden of proof in today's case. We have to prove these claims by a preponderance of the evidence. Simply put, we have to prove more likely than not. And members of the jury, today in court, we're going to meet this burden by showing you how the defendant put profits over people. First, you're going to hear about how the defendant actually attracted minors to their store in the first place. You're going to hear from Logan Carter's best friend, Devin Andrews. Devin Andrews is going to tell you about how the fun variety of colors on advertisements and fruit and candy flavored vapes are what drew her and Logan into vaping in the first place. But you're also going to hear from the defendant herself, and she's going to tell you about the cloud chasing competition she holds at her store. In court, you're going to hear that these competitions are where adults compete to blow the largest clouds of vapor they can. You're going to hear that these competitions were open to anybody, including minors. Secondly, you're also going to hear about how Logan Carter was able to purchase from Vicks Vaporium in the first place. You're going to hear that after using his $15 fake ID, the employees at Vicks didn't give it a second look. You're going to hear that after the first few times shopping at Vicks, they didn't even bother checking at all. Members of the jury, how could a 14-year-old boy pass as a 21-year-old man? Wouldn't a responsible business owner make sure that their employees checked IDs every single time? Lastly, you're going to hear about how vaping is what led to Logan Carter's death. Today in court, we're going to call Dr. Bill Robinson to the stand, the doctor that conducted the autopsy on Logan Carter's body. He's going to explain to you how these toxic chemicals and vape liquids are what led to Logan Carter's death. Members of the jury, Logan Carter died because the defendant put profits over people. On March 19th, Logan Carter's mother found her 15-year-old son unconscious, unresponsive, and unable to breathe. Logan Carter died because the defendant put profits over people. At the end of this trial, my co-counsel Hermela Gattacho will come before you and ask you to hold the defendant liable. Thank you.
Thank you, Mr. Joseph. Ms. Weiner.
Yes, Your Honor. Before I begin, if I had been permitted to object during opposing counsel's opening statement, pursuant to Rule Special Objection 54A, I would have objected argumentative because in his description of the burden, he argues a conclusion that's contrary to the charge of the court. The verdict today only deals with liability, and the issues of damages will be reserved for a later time.
All right.
Your Honor,
Mr. Joseph, go ahead. Yes.
Your Honor, may I respond?
You may actually, before you do, I have a question from Ms. Weiner. You're directing me to Rule 54, and I think I may be looking at the wrong thing. Rule 54 in my materials is the critique. So what are you directing me to?
Yes, Your Honor. In the most updated version of the rules, Rule 54A pertains to special objections.
And that immediately precedes the rules of evidence. Is that right?
Yes, Your Honor.
Okay, I don't have it. Go ahead, read it to me.
Your Honor, pursuant to Rule 53A, special mock trial objections, objections during opening and closing may be raised after opening statements if a team believes an objection would have been proper during.
Excuse me. So this just relates to the timing of your objection, not the substance of it.
Yes,
Is
Your
that
Honor.
right? Very good. Gotcha. And your argument is simply your objection simply was an argumentative portion of the argument.
Yes. Your Honor.
Very good. Mr. Joseph, response.
Yes, Your Honor. For the plaintiff to prove negligence in today's case, they have to prove that damages exist. The specific contents of these damages weren't being discussed in my opening statement, Your Honor. Simply that damages exist. That is what we need to prove negligence and meet our burden of proof in today's case. The specifics of those damages were never discussed in my opening statement.
All right. My ruling or my hypothetical ruling is to deny the objection. There is a fine line between an opening statement and a closing argument. But Mr. Joseph is correct. The damages are an element of the plaintiff's burden. And as I understand it, his statement that they will meet that burden falls squarely within what is permissible in an opening statement. Therefore, the objection is overruled. And you may proceed with your own.
Yes, Your Honor.
May it please the court. To a parent, the death of a child is unthinkable. And of course, Logan's parents, Tristan and Nick Carter, want answers and someone to blame. But members of the jury, the Carters deserve the truth, even if it's difficult to hear. The truth is that even at 15, Logan Carter knew the risks of vaping. He felt those risks, and he ignored them. The plaintiff has the burden to prove to you today that there was a duty, a breach, and that breach caused Logan Carter's death. And they must prove first that Vicks Vaporeum had a duty to not knowingly sell to minors, and that they breached that duty. In order to find Vicks liable, they have to prove by a preponderance of the evidence that the products from Vicks Vaporeum were the ones that killed Logan, and that Vicks could have reasonably foreseen that their breach of knowingly selling to Logan would have caused his death. You'll see that they can't prove that the vaping products sold by Vicks to Logan caused his death. You'll hear that the chief medical examiner won't be able to connect Logan's death to any product that was sold to him by Vicks Vaporeum. They have to prove he died from that sale. Not vapes other people got for him, not vapes he shared, not vapes from anywhere except Vicks Vaporeum. If they fail to prove that, they fail to meet their burden. You'll see that they can't prove anyone in Vicks Vaporeum knew Logan was underage. Now, Mr. Joseph told you that he had to present as 21, but members of the jury, you'll learn at the time, the statute said he had to present as 18. And you'll hear he used a fake ID to do that. Joseph Camille, the PR representative that reviews store operations, will testify that Vicks Vaporeum was required to verify Logan's age the first time, and they did just that. Devin Andrews will tell you that after they went to Vicks Vaporeum the first time, Vicks Vaporeum was not required to verify Logan's age after that, and no reason to believe he was under 18. Now, members of the jury, if they fail to prove that Vicks Vaporeum knowingly sold to Logan, they fail to meet their burden. And not only does the plaintiff have to prove their negligence claim, they have to prove that Logan did not assume the obvious risks of vaping. And the evidence will show that Logan knew vaping was bad, and you'll hear he admitted to his best friend that he knew vaping was hurting him. And he kept vaping anyway. Devin Andrews will tell you that they started vaping together in 8th grade before they even knew about Vicks Vaporeum. And they knew they'd have to lie about their ages to get products. And you'll learn today that Logan was caught multiple times vaping. His mom, Tristan Carter, will tell you Logan was caught vaping by his school and suspended, and his parents punished him too. Logan's cousin and ICU nurse, Kennedy Womack, will testify that when she found out Logan was vaping, she told him just how dangerous it was. And she'll tell you he looked her in the eye and told her he understood the risks. Well, he felt them too. Logan's mom and best friend will tell you Logan was losing weight, wheezing, coughing, couldn't catch his breath. The chief medical examiner will testify that in the days leading up to Logan's death, he was vaping multiple hours a day. And you'll hear he was even hospitalized days before his death. And even that didn't stop him. You'll hear Logan took the risk of using a fake ID. You'll hear he lied to his parents when they caught him. He ignored a nurse's warnings about the dangers of vaping, and he didn't stop even when he was getting sicker. Profits over people, that's what Mr. Joseph told you in his opening statement. Well, Ms. Vavrick will tell you, selling to kids just loses her money. And her first priority is to make sure that she follows every legal obligation to prevent selling to minors. No parent wants to hear that their 15-year-old son may have played a role in his own death. It's a hard truth, but members of the jury, Logan Carter knew the risks. He felt those risks and he ignored them. At the end of today's trial, we ask that you find Vicks Vaporeum not liable. Thank you.
Thank you, Ms. Weiner. All right, the plaintiff may call their first witness.
Yes, Your Honor. At this time, the plaintiff calls Ms. Tristan Carter to the stand.
Good afternoon. Could you please introduce yourself to the jury?
Hi, my name is Tristan Carter.
Why are you testifying in court today, Ms. Carter?
I'm here because my son Logan, he passed away.
I'd like the jury to get to know a bit more about your son Logan, since they can't meet him today. What was Logan like?
Logan was just, he was just an amazing kid. It's funny, he was smart, and I don't know, he just had a way of brightening up your day.
How was Logan at school?
He was good. He was always very invested in his classes. He loved to learn, and his teachers loved him. He never really got into any type of trouble until one time back in February when he got caught vaping.
Ms. Carter, what is vaping?
As I understand it, it's a type of electronic cigarette.
You mentioned your son was caught vaping at school. Could you tell us a bit more about that?
Yes, the school called me and said that he had been caught with a few other kids behind a dumpster, and he was going to be suspended. Well, yeah, you can assure yourself that I gave him, a strict talking to, as a parent should, and well, he told me it was a one-time thing.
What did Logan tell you about why he tried vaping?
He had a bit of a sweet tooth. He loved any type of candy. And he said that the vape smelled sweet. He just wanted to see if it tasted the same. And that's why he did it.
You said you had a conversation with your son. What happened after you had a conversation with him?
Well, like I said, I talked to him and he seemed to understand. My cousin Kennedy actually talked to him too. She's a nurse, so she told him, more about the health stuff, aspects of it. I thought it was over after that, but it wasn't really.
What do you mean by that?
Well, I thought everything was over, but he ended up developing a cough. It was really phlegmy, like in his chest, and one night he was having trouble breathing, so we took him to the hospital.
What'd you learn at the hospital?
They said that he had a lung infection, so they gave him some medicine and some breathing treatments, and he seemed to be fine after that.
Now, Ms. Carter, I'd like to talk about March 19th. What were you doing that evening?
And it was a normal day. It's funny how a normal day can turn into the worst day of your life. I remember I was just at home that day, and Logan was out with some friends, and he came home at night, and he said his cough had come back, and he said he was going to go to bed early, to get some rest. And he said that I love you, and I said I love you too.
Did you go check on your son that evening?
Yes, I did. I was concerned because of the cough, so I went to go check on him before I went to bed. He seemed fine. He seemed fine at first. I went in and I saw him, and he seemed pale, and I touched him, and he was cold and clammy, and I noticed he wasn't breathing, and I screamed and I yelled for Nick, and I called 911. It was too late, really.
Ms. Carter, did you ever find out what caused your son Logan's death?
The doctors told me it was asthma that led to a heart attack. A heart attack at 15.
Miss Carter, do you know how your son found out about vaping?
And I didn't really know. After he passed, I was looking through some of his stuff, his social media, and well, I saw an ad that made me think otherwise.
Would you recognize a picture of that ad if I were to show it to you in court today?
Yes, I would.
Ms. Getz, could you screen share Exhibit 7 constructively out of the presence of the jury? Ms. Carter, what is this?
That's a picture of Logan's phone with the ad on it that I took.
Does it look like a fair and accurate representation of the picture you took?
Yes.
Your Honor, at this time, the plaintiff offers Exhibit 7 into evidence.
All right, is there any objection?
Yes, Your Honor. The defense has two objections. In pursuant to Rule 49, lack of foundation that this advertisement was sent by Vicks Vaporeum. And in addition, in pursuant to Rule 801, this is hearsay.
Your Honor, beginning with the stipulation 49 that no foundation has been laid that this is Vicks Vaporeum, if I may proffer, we'll go into a line of questioning as to who Ms. Carter believes that this ad was created by, as the foundation will be laid as going through the post of this ad and the username, which is above, indicated as Vicks Vaporeum. As for the hearsay objection, Your Honor, these are statements made by the party opponent, as will lay foundation for in future questions.
May I respond? Oh, excuse me.
Please finish, Cora. Are you finished?
Simply reiterating that statements made by party opponents do not fall under the Rule 801 for hearsay.
Very good. Mr. Mayette?
Yes, Your Honor. Pursuant to Rule 49, that's not how lack of foundation works. They cannot lay foundation after the entry of the exhibit, and they have laid no foundation that this advertisement was sent by Vicks Vaporeum. And as for hearsay, they have laid no foundation that the party opponent statements are on this exhibit.
May I respond, Your Honor?
You may.
Your Honor, this exhibit directly states that it is by Vicks Vaporeum, an ad for Vicks Vaporeum selling the products that they sell at Vicks Vaporeum. It is clearly a post made by the party opponent and so is a statement by the party opponent in court today, as it's an ad for Vicks Vaporeum.
All right. I'm going to overrule the objection as to hearsay. As to foundation, in another jurisdiction, I might be inclined to accept your statement in faith that you will connect up later, but I construe Rule 49, under which we're proceeding, to require, as Mr. Mayette does, that you lay the foundation before the exhibit be introduced. So I'm going to sustain the objection and require you to lay the necessary foundation before the exhibit be admitted.
Yes, Your Honor.
Ms. Carter, do you know who posted this picture?
It says right there at the top.
Objection, Your Honor. And pursuant to Rule 801, this is hearsay because the exhibit has not been entered into evidence. They can't use foundation from the exhibit to enter the exhibit.
Your Honor, may I respond?
Well, I'm going to declare us constructively in a bench conference. Your point is right, Mr. Mayette, as far as the jury is concerned, but it is appropriate to make the necessary showing out of the presence of the jury if it's likely to be prejudicial. So you may proceed, Ms. Carter.
Yes, Your Honor.
Yes, Your Honor. Ms. Carter, do you know who posted this image on Autogram?
Like I said, it says right there, Vicks Vaporeum, sponsored. It's their ad.
Do you know who Vicks Vaporeum is?
Yes, it's a smoke vape shop in Miltonville.
Your Honor, at this time, we've laid the foundation of who Vicks Vaporeum is and how they belong to this ad. Your Honor, at this time, we offer this evidence, we offer Exhibit 7 into evidence.
All right, Mr. Mayette, any objection?
Yes, Your Honor. I stand by my lack of foundation objection. The statement sponsored by, or excuse me, not even sponsored by, but sponsored Vicks Vaporeum is not enough foundation to show this exhibit in front of the jury.
Your
All
Honor,
right, you may.
Your Honor,
Go ahead.
I apologize, Your Honor. The statement sponsored by, and rather the fact that there is the actual name of the username in the post indicates that this was a business record. This was posted by the business Vicks Vaporium. If it was someone imitating Vicks Vaporium or anything further, there wouldn't be the sign sponsored by, as it shows that this is an ad created to advertise a product by this company and this store in Miltonville.
Your Honor,
Yeah, all right, you may go one more time, Mr. Mayan.
yes, Your Honor. If they intend to only use Logan's statement, the liking of the ad, we move to redact all other portions of the advertisement. However, if they want to use, it seems that they're attempting to use a business record exception, and I stand by my objection. There's lack of foundation for that exception to hearsay.
All right, Ms. Carter, are you seeking to have it admitted on a limited basis? Or do you
No,
wish-
Your Honor. I apologize for interrupting.
No, you go right ahead.
Your Honor, firstly, I did not imply the business record exception, rather the exception that this is a statement by a party opponent, which we have laid foundation for. Secondly, we are not going to actually address the statements of who have liked this image, but rather the ad itself. And so if opposing counsel would like us to constructively redact the liked statements, we're happy to do so. But as for the ad, we have laid the proper foundation that this is from Vicks Vaporium, and that since it is from Vicks Vaporium, it is a statement from a party opponent and is not hearsay.
All right, I'm going to overrule the objection. The evidence certainly supports that this was on his phone. And if the defense wants to, whether or not it wants to contest the issue of whether or not it in fact was generated by Vicks Vaporium, that's Vaporium, that's going to be an issue for the jury. So objection overruled. Exhibit 7 is admitted.
Yes, Your Honor.
Your Honor, Ms. Carter, what stood out to you in this ad?
Well, I mean, it stood out to me that if it wasn't for that vape pen, I mean, this could be an ad for anything. I mean, it could be an ad for candy. It has gummy bears, it has Skittles, it has all those fruity flavors and colors, and it's just like, it was heartbreaking to me because, like I said, Logan had a sweet tooth, and all that candy, it just reminded me of something he could like.
Ms. Carter, do you know if your son ever owned a vape pen like the one in this ad?
Yeah, actually, my cousin Kennedy, she went through his room and she found it and showed it to me.
Would you recognize a picture of that vape pen? Oh, Ms. Getz, could you screen share Exhibit 3 constructively out of the presence of the jury? Ms. Carter, what is this?
It's the vape pen she found and showed me.
And does it look like a fair and accurate representation of the vape pen your cousin Kennedy found?
Yeah, I mean, she showed me, and trust me, I remember it quite clearly.
Your Honor, at this time, the plaintiff offers Exhibit 3 into evidence.
Any objection, Mr. Mayan?
The defense has no objection, Your Honor.
Very good. Exhibit 3 is admitted.
Ms. Carter, would you mind pointing out to us the warnings of the health risks of vaping on this pen?
I mean, there aren't any. There's nothing about addiction, about cancer, about health risks. I mean, there's nothing on that pen that can tell a 15-year-old kid this can kill you. I mean, it's just, there's nothing.
Thank you, Ms. Getz. You can stop screen sharing. Thank you, Ms. Carter. Thank you, Your Honor. At this time, I have no further questions.
Very good, Mr. Mayan.
Yes, Your Honor. Ms. Carter, on direct examination, you offered your opinion that Logan got vapes from Vicks Vaporium, but you never saw Logan go into Vicks Vaporium, did you?
No, I wasn't on that part of town that often.
You never saw Logan buy products from Vicks Vaporium?
No, I was never in Vicks Vaporium.
You never saw Logan use products from Vicks Vaporium?
Not specifically, no.
I'm now showing you what has been entered as Exhibit 3. Your Honor, I ask that the time be stopped until my screen sharing coordinator pulls up Exhibit 3.
Yeah, go ahead, stop time.
Oh, it's pulled up, Your Honor.
Yeah, so there.
On direct examination, you testified this vape was from Vicks Vaporium, but you didn't see Logan bring this vape into your home,
Objection, Your
did you?
Honor, to misquoting my witness. Ms. Carter did not state that this pen was from Vicks Vaporium, but rather that it looks like it could have been and that it was found in Logan Carter's room.
All right. I think she's probably right about this, Mr. Mayette, but I'll hear your response.
Your Honor, Ms. Carter insinuated throughout the entire direct examination that this vape was from Vicks Vaporium. This is why she's bringing the suit. I'm entitled to a thorough and sifting cross-examination, and I'm simply using this evidence to attack her opinion that this vape is from Vicks Vaporium.
All right. I think you're probably right about what exactly what you said, but he's right about the fair characterization. So the objection is overruled.
Yes, Your Honor.
Yes, Your Honor. Now, Ms. Carter, you didn't see Logan bring this vape into your home.
No, but Mr. Mayette, like you said, I think he got it at Vicks. It looks exactly like the one on the ad. I mean, it's identical.
Ms. Carter, is it your testimony that you saw Logan bring this vape into your home?
Oh, no, I didn't say that. I'm just saying what you said before, that I think it was from Vicks. That's true, but I never saw him bring it in.
And Logan didn't tell you that he got this vape from Vicks Vaporium.
Never got the chance to.
So that's a yes to my question. Logan never told you he got this vape from Vicks Vaporium.
No, he didn't get the chance.
After Logan died, your son Preston showed you Logan's social media profile.
Yes.
So of course you knew Logan's Autogram username.
Yes.
I'm now showing you what has been entered as Exhibit 7. This is the advertisement you found on Logan's phone.
Yes, it is.
Logan did not delete this advertisement.
I don't know if you can delete advertisements, but I guess not.
And as far as you know, Logan didn't block this advertisement.
Not as far as I know. I mean, again, these companies, they put stuff out like this for kids to be drawn into it. So he was hooked.
So that's a yes to my question. Logan did not block this advertisement?
No, he was drawn in by the ad.
Logan actually liked this advertisement.
Exactly. He liked it. He shouldn't even be in a position where—
Objection, Your Honor. This witness is non-responsive. I'm not asking about her opinion on whether the ad should have appeared on his feed. I'm asking if Logan Carter liked the advertisement. The witness was non-responsive.
Well, I'm going to overrule that objection. That there is certainly a point where witness becomes non-responsive, but it was close enough related that I'm not going to intervene in that regard. That objection is overruled. You may proceed.
Yes, Your Honor. After Logan was caught vaping at school, you talked to him.
Yes.
In that conversation, Logan said it was his first time vaping.
That's what he told me.
He told you that it was illegal for minors to get vapes with nicotine.
Again, that's what he said.
You punished Logan, right?
Yes, I did.
You thought it was sufficient in letting him know vaping was dangerous.
Yes, I did a one-time punishment for a one-time offense.
He also told you that he had a conversation with Kennedy Womack.
Yes.
Ms. Womack is an ICU nurse.
Yes, she is.
And you believe that after Logan spoke to Ms. Womack and you talked to him and punished him, that Logan got it.
I thought so. I didn't realize how far gone it was already, that he'd become addicted to this stuff.
Objection, Your Honor. I move to strike the witness's statement as improper lay witness testimony. Ms. Carter is not a medical expert, and therefore she is not in a position to conclude that Logan Carter was in fact addicted.
Your Honor, may I respond? Your Honor, under Rule 701, as Mr. Mayette has just said, she's entitled to a lay witness opinion. He's asked her a question about her son, and she's giving her rationally based opinion on how he perceived vaping. This does not require expert testimony, as she's not asserting the medical facts that he was medically addicted to vaping, but rather her perspective. You don't need an expert knowledge to understand that someone may have been addicted to a vaping product. So under Rule 701, this is a lay witness opinion.
May I respond, Your Honor?
Briefly.
This is not rationally based on the witness's perception because pursuant to 701C, this is a conclusion that relies on expertise and technical expert knowledge. And because Ms. Carter is not an expert or a mental health professional, she cannot lay the foundation for this opinion. She cannot say this opinion to the jury, and we move to strike.
Your Honor.
No, I'm overruling the objection. Your point, I think, has some merit, but only as a matter of credibility, not admissibility. Statutes. You may proceed, Ms. Corey.
Yes, Your Honor. You believe, and you now know, that after Logan spoke to Ms. Womack, he kept vaping.
Yes, like I said, he'd been hooked on this stuff now.
You now know that after you punished Logan, he kept vaping.
Yes, again, he was hooked. He was addicted. You can't blame somebody for their own addiction.
So that's a yes to my question. He kept vaping even after you punished him.
Yes, again.
Ms. Carter, in the weeks leading up to his death, Logan was coughing.
Yeah.
He lost weight.
A bit, yes.
Logan struggled to breathe.
Yes, that's why we took him to the hospital.
And he stayed at that hospital for 3 nights.
Yes.
And you now know that after Logan was coughing, lost weight, struggled to breathe, and stayed at the hospital for 3 nights, he kept vaping.
Yes, Mr. Maya, it's really heartbreaking for me. I mean, after all of that, he was that addicted to those products that he couldn't stop.
No further questions, Your Honor.
Thank you, Mr. Mayette. Ms. Corey, redirect?
No redirect, Your Honor. May this witness be excused?
If there's no objection, Ms. Carter, you're excused. The plaintiff may call their next witness.
Your Honor, the plaintiff calls Devin Andrews to the stand. May I proceed?
You may.
Good afternoon. Could you please introduce yourself to the jury?
Hi, I'm Devin Andrews.
Well, tell us a little about yourself.
Yeah, okay. I'm 16 now. I'm a sophomore at Miltonville High, and my parents, they own a restaurant downtown.
Well, why are you here today?
Well, I'm here because Logan Carter was my best friend, and we did everything together.
What was your relationship like with Logan?
Well, it all started probably the first day of 6th grade, on the bus. He sat down next to me and we started talking about a video game that we both really liked. And then after that, we were inseparable. We did everything together.
Well, Miss Andrews, I want to talk about your experiences vaping with Logan. How did you and Logan first start vaping?
It was 8th grade, I think, and we were invited over to Ty Hamilton's house, and he was kind of popular, you could say. And he took out this pen, this like strawberry vape, and he put it in his mouth. He inhaled, and when he exhaled, all this smoke came out, and it smelled like strawberries and candy. And well, he asked if we wanted to try it, and we said yes.
How did you and Logan react to being offered trying vaping?
Well, before we said yes, we hesitated. I know about cigarettes and stuff like that, but I asked Ty, and he told me that it was just water vapor and flavoring. So, he assured us that it was harmless, and that's why we tried it.
So did you and Logan continue vaping?
Yeah, we did. It didn't hurt when we tried it. We didn't even cough. and all the, I guess, cool kids were doing it. I know it sounds stupid now, but we thought it'd be fine.
Well, when you were vaping, where did you and Logan get your products from?
At first, we would get Ty's sister to buy things from us, or not from us, for us. But she had just graduated high school, so she was going to go to college in the fall. And that's when we decided to start going to Vic's Vaporium.
How did you and Logan get your products from Vic's Vaporium?
Well, one day after class, Logan overheard some older kids talking about this shop, Vic's Vaporium, and how, we could get a fake ID, any passable fake ID, and buy whatever we wanted from there. So that's what we decided to do.
And did you and Logan ever get your fake IDs?
Yeah, it was really easy, honestly. We paid them $15 each and got 2 fake IDs. I mean, for $15, we weren't really expecting quality. So when we went there for the first time, we were really nervous. But I mean, the cashiers, they just looked at them once and let us buy our products.
And then after that, what did you and Logan do?
Well, we had gone to Vic's Vaporium and they allowed us to buy whatever we wanted. So we just kept going.
Well, now I want to talk about how Vic's Vaporium actually advertised their products to you and Logan. Have you ever seen an advertisement for Vic's Vaporium?
Yeah, I've seen lots of them.
How would they usually advertise to you?
Well, every time we walked into the store, we would get a text on our phones and it would say, try this new flavor, or, new flavors in stock. And then we'd also get an ad at the top of our Autogram feed. And then, we'd see them on different social media websites like FaceTube and things like that.
Would you recognize a picture of one of those Autogram ads if I were to show you it in court today?
Yeah, of course.
Ms. Getz, could you please screen share Exhibit 7? It's already been entered into evidence. Now, Ms. Andrews, is this the kind of ad you would see for Vic's Vaporium?
Yeah, I mean, I've definitely seen this before.
Have you seen any ads similar to that one?
Yeah, all over Autogram and FaceTube and things.
And how did you and Logan react to seeing that ad?
Well, I mean, it looked enticing, I guess. It looked fun, Vape the Rainbow. It's just like the Skittles commercial. And then there's all these flavors. Like I said, it tasted like candy. So, we thought it would be perfectly fine.
Ms. Andrews, do you see any warnings on that advertisement?
No, there are none. It doesn't say anything. It doesn't say anything about how we had to be older. It doesn't say anything about how it could kill my best friend.
Thank you, Ms. Getz. You can stop screen sharing. Now, Ms. Andrews, I want to talk about how vaping actually affected Logan Carter. Did you notice any symptoms when you would vape together?
At first, it was perfectly fine. Like I said, we weren't even coughing when we tried it, but towards the end, the last few months of Logan's life, I noticed how he started coughing a lot more. Sometimes he would be in class and he wouldn't be able to stop, or I guess those last 2 weeks when it got really bad, he started looking pale and clammy and had even lost a lot of weight.
Did you notice anything about his symptoms?
Just that every time he vaped, they would get worse.
Thank you, Ms. Andrews. I have no further questions.
All right. Thank you, Mr. Joseph. Ms. Weiner Cross.
Yes, Your Honor. Miss Andrews, before you ever went to Vic's Vaporium, you and Logan had older kids purchase your vapes, right?
Yeah, Ty Hamilton's sister.
And after those older kids moved away, you had to obtain a fake ID from kids at your school.
Yeah, we did. Just $15 fake IDs.
And you agree that this fake ID was a passable one.
I mean, I guess so, passable enough for us to get our products, but
That's a yes to my question. You agree that your fake ID was passable, right?
yeah, I guess it was good enough, but again, for $15, we weren't expecting that much.
And you knew with those fake IDs that you would have to lie about your age.
Yeah, we just thought it was one of those things. We weren't old enough just yet, but it would be fine.
And Logan used this fake ID to actively deceive the clerks at Vic's Vaporium, right?
I guess if a 14-year-old kid can deceive those clerks, then yeah.
That's a yes to my question. He actively deceived the clerks at Vic's Vaporium with his fake ID.
Yes, ma'am, he was able to.
And the first couple times you went to Vic's Vaporium, they did check your IDs, right?
Yes, the first few times, but after that, they just stopped looking at them.
Well, they didn't need to look at your fake IDs the next couple times because they knew you, right?
Objection, Your Honor. Lack of personal knowledge pursuant to Rule 602. May I be heard?
Amen.
This witness doesn't have the personal knowledge to know all of the business practices of Vic's Vaporium. She doesn't know anything about the law or legality of checking IDs and wouldn't know whether or not it's required to check IDs every single time at this vape store.
Ms. Weiner?
Yes, Your Honor. I haven't asked Miss Andrews about any of the practices at Vic's Vaporium, only if they stopped checking her IDs after the first couple times that she went there. I'm not asking her to testify to the legality of verifying IDs or what their duty is, just if they did it or not.
Your Honor, may I respond?
You may.
Opposing counsel specifically asked this witness if she knew about she knew they were required to check IDs at Vic's Vaporium. That's definitionally asking about the legality of checking IDs, as opposing counsel asked this witness if they were required to. That goes into the business practices of Vic's Vaporium, and my witness doesn't have the personal knowledge to know that.
May I be heard, Your Honor?
Yes, you may.
I never asked Miss Andrews if the clerks at Vic's Vaporium were required to check her ID. I asked her if they knew who she was and therefore didn't check her ID. I never asked her about the requirements that any of the clerks had to meet or any of the legal obligations that the clerks had.
Your Honor, may I respond?
You may.
Opposing counsel directly asked my witness if she knew if Vic's Vaporium was required to check her ID because they already knew her. She asked both of those questions, Your Honor. That falls out of the personal knowledge of my witness pursuant to Rule 602.
I'm going to overrule the objection. The charge significant extent on the care applied and the reasonableness of the conduct of Vicky herself, as well as persons operating at her direction, which I think this goes to. So the objections overruled. You may proceed, Ms. Warner.
Yes, Your Honor. So, Miss Andrews, after the first couple times, they didn't verify your ID again because they knew who you were, right?
I'm not sure. It wasn't the same person every time who checked us out.
Well, there was a clerk who knew you, right?
Yes, there was one.
And she eventually stopped working there.
Yes, I think she was fired.
And after that, she made it harder for you, or her absence made it harder for you to get vapes.
Yes, I mean, in general, we just weren't feeling as comfortable. So our older friends, they would come to us. They would come with us to Vic's Vaporium.
Right. After she left, you had to bring older kids with you to the Vaporium. Older kids with you.
Yeah.
Now, you know that Logan got in trouble multiple times for vaping, right?
Yes, that's right.
He was caught twice by his teacher.
Yes, that's when he started coughing in class and couldn't stop.
And one of those times he was even suspended.
Yes, that's right.
But he continued to vape, right?
Yeah, he did.
Well, you and Logan were both caught vaping by Kennedy Womack, right?
Yes. We thought we were home alone, but we were out on the porch and Kennedy walked right up and, we couldn't deny it. So, yes.
And after that, she lectured you about vaping, right?
she told us all about nicotine and all these things, but I mean, like I said, we were just smoking water vapor and flavoring, the liquid candy stuff. We didn't know that we were using all of these horrible things.
Well, she told you it was unhealthy.
Yes, she did.
And she told you that there were negative side effects.
Yes, she was talking about nicotine and cigarettes, but we didn't think it applied to us.
Well, you both ignored her warnings, right?
I guess you could say so.
And Logan continued to vape.
Yes, I mean, we had been doing it for so long. I don't know if it was an addiction, but we couldn't stop. It was so hard to stop.
Miss Andrews, you never lost weight after vaping, right?
I didn't know.
You didn't contract a cough after vaping.
That's right. I was okay.
But in the beginning of March 2020, you noticed that Logan did lose weight after he was vaping, right?
Yes, he did.
And he did lose his breath.
Yes, he would.
And he was coughing all the time.
Yes, that's right.
And he even told you that vaping made it worse, right?
Yes, and that's why he...
Oh, hearsay, may I be heard?
You're back.
Pursuant to Rule 801, this is an out-of-court statement being offered for the truth of the matter asserted.
May I respond, Your Honor?
Please.
Your Honor, pursuant to Rule 801 D2A, this is a statement by a party opponent. Logan Carter is a party opponent because the party representing him is his estate. So any statements by Logan Carter are admissible under Rule 801 D2A.
All right, let me reread 801 D2A. All right. You may proceed, Mr. Joseph. Yes.
Your Honor, Logan Carter isn't their party opponent. It's Tristan Carter. This is a statement made by Logan Carter, not Tristan Carter, and is therefore hearsay. Tristan Carter is the one representing the state and is their party opponent.
May I respond, Your Honor?
You may.
Your Honor, the party, Ms. Tristan Carter is representing the estate of Logan Carter. So therefore, any statements by Logan Carter do fall under the rule, the exception to hearsay 801 D2A. It's still a statement by a party opponent because Tristan Carter is representing Logan Carter's estate.
Mr. Joseph, anything further?
Your Honor, I stand by my hearsay objection as Tristan Carter is the party representative.
Very good. It's an interesting question. And I guess I'm glad there's no Court of Appeals in Milton County. But I think in terms of the substance of the underlying intent of the rule, that this falls within it, so the objection is overruled.
Yes, Your Honor.
Yes, Your Honor. So, Ms. Andrews, Logan even told you that vaping made his health worse.
Yes, and again, that's why he was trying to stop. He tried so hard to stop, but he just couldn't.
Well, you know that after this conversation where Logan told you vaping made his health worse, he was hospitalized, right?
Yes, he was.
And the last time that you vaped with him was before that hospital visit.
That's right.
And you don't know if he stopped vaping after this.
I can't be sure, no.
You don't know if he went to Vicks Vaporium after this hospital visit.
No, but every time, before that, he would always go with me. I don't think he would go without me.
Well, despite being punished for vaping, Logan didn't stop, right?
I guess not. Like you said, I didn't know.
Despite having adults telling him to stop, Logan kept vaping, right?
He was hooked, addicted. I don't know what else he could have done.
That's a yes to my question. After having adults telling him to stop, Logan kept vaping.
Yes, that's right.
And despite being physically ill, Logan didn't stop vaping.
No, I guess not. He was 14. He was a kid, just like me.
No further questions, Your Honor.
All right, thank you, Ms. Weiner. Mr. Joseph?
No redirect, Your Honor. May this witness step down.
There's no objection. The witness is excused. Plaintiff may call their next witness.
Yes, Your Honor. The plaintiff calls Dr. Bill Robinson to the stand.
Very
Good
good.
afternoon. Could you please introduce yourself?
Good afternoon. My name is Dr. Bill Robinson.
What do you do for a living?
I'm the Chief Medical Examiner for Milton County.
Dr. Robinson, why are you testifying in court today?
I conducted the autopsy of Logan Carter, and I'm here to testify about the cause of his death.
Dr. Robinson, I'll ask you more about the cause of death of Logan Carter in a moment. But first, I want the jury to get to know a bit more about your background. Can you tell us where you went to school?
I attended Emory, where I earned a bachelor's degree in history and biology, and I later went on to obtain my MD, also from Emory.
Where have you worked since you completed your education?
I worked for the Chief Medical Examiner for Milton County for about 10 years as an assistant medical examiner, and I later assumed the role of Chief Medical Examiner after they had retired.
Dr. Robinson, are you board certified in any medical field?
Yes, in forensic pathology.
Have you ever testified in court before?
About 200 times as an expert in forensic pathology.
Can you tell us how many autopsies you've completed in your career?
Over 2,000.
Your Honor, at this time, we offer this witness as an expert in forensic pathology.
All right. Thank you, Ms. Gettichow. Ms. Rapping, do you wish to be heard on the witness's qualification to testify as an expert?
The defense has no objections, Your Honor.
Very good. You may proceed, Ms. Gettichow. I will reserve an actual ruling until such time as there is an objection.
Yes, Your Honor. Now, Dr. Robinson, can you tell us what your day-to-day job as a medical examiner involves?
My main job is to complete autopsies in order to determine the cause of death.
Dr. Robinson, can you tell us what an autopsy is?
An autopsy is an examination of a dead body in order to determine the cause of death.
How can you determine the cause of death from an autopsy?
There are two phases to an autopsy. The first is the external examination, and the second is an internal examination.
I want to ask you about those two phases one by one, starting with the first one you mentioned. What do you do when you're conducting an external examination?
The first thing that I do in an external examination is take pictures of the body. I also record any injuries, and I also measure the height and weight of the body.
How can you determine the cause of death from conducting the external examination?
Anything that is relevant in potentially identifying the cause of death is noted, and such as viewing injuries and seeing if those injuries had a potential in contributing towards death.
What about that second phase you mentioned? What do you do in the internal examination?
The internal examination doesn't always occur. In an internal examination, the internal organs are weighed and their characteristics are recorded.
How can you learn more information about the cause of death by conducting the internal examination?
The internal examination allows me to determine whether or not an organ was damaged or abnormal.
Throughout your investigation into the cause of death of Logan Carter, what materials were made available to you?
In addition to the body, I had access to a toxicology report, as well as statements from Logan's family regarding his medical history.
Now, is this method that you just mentioned of determining the cause of death from an autopsy standard in your field?
Yes, it is.
Did you conduct your autopsy in this case according to those standards?
Yes, I did.
Would you recognize a copy of your autopsy report of Logan Carter?
I would, yes.
Ms. Getz, could you please screen share Exhibit 1? Can you go to the next 2 pages, Ms. Getz? Dr. Robinson, can you identify this document?
Yes, it is the autopsy report of Logan Carter.
Is it an accurate copy of your autopsy report?
Yes, it is.
Your Honor, the plaintiff offers Exhibit 1 into evidence.
Very good. Ms. Rapping, any objection?
No objection, Your Honor.
Exhibit 1 is admitted.
Ms. Getz, could you please go back to the first 2 pages of this document? Dr. Robinson, what did you determine was the cause of death of Logan Carter?
I determined that there were 2 causes. The primary cause of death was a heart attack or a myocardial infarction, and the secondary cause of death was popcorn lung or bronchiolitis obliterans.
I'm going to ask you to break down those 2 causes one by one, starting with that primary cause. Why did you conclude that Logan Carter died of a heart attack?
The stress on the heart was triggered by a decrease in oxygen production, and that occurred due to an asthma attack, which happened the evening of his death.
What about that secondary cause you mentioned? What exactly is popcorn lung?
Popcorn lung is a lung condition in which the small air sacs inside the lungs, called alveoli, become inflamed and scarred. It reduces the lung's capacity, and it makes it much more difficult to breathe.
In your autopsy, did you find that Logan Carter had lung damage consistent with popcorn lung?
Yes, the lung tissue I examined had very extensive damage, and the alveoli were both inflamed and scarred, and all of this is evidence of popcorn lung.
From your autopsy, were you able to determine how long this damage had been going?
The amount of damage led me to believe that it had been ongoing for quite some time.
Thank you, Ms. Getz. You can stop screen sharing this document. Dr. Robinson, what can cause popcorn lung?
Popcorn lung is typically caused by the inhalation of diacetyl, which is a food additive used in vaping liquids to increase flavor.
Did you find any evidence in your investigation that Logan Carter had the chemical diacetyl in his system when he died?
Yes, from the toxicology report.
Would you recognize a copy of that toxicology report?
Yes, I would.
Ms. Getz, could you please screen share Exhibit 2? Dr. Robinson, can you identify this document?
Yes, it is the toxicology report.
Is it an accurate copy of the toxicology report?
Yes, it is.
Your Honor, the plaintiff offers Exhibit 2 into evidence.
All right, any objection?
No objections, Your Honor.
All right, Exhibit 2 is admitted.
Dr. Robinson, from this toxicology report, what chemicals were in Logan Carter's system when he died?
Logan Carter's system had elevated levels of glycerin and glycol, as well as diacetyl and nicotine.
Are any of these chemicals commonly found in vaping products?
Yes, glycerin, glycol, and diacetyl are all common ingredients found in vaping liquid compounds.
Thank you, Ms. Getz. You can stop screen sharing this. Dr. Robinson, are there any health risks that are associated with vaping?
Yes, numerous studies suggest that vaping is potentially bad for both the heart and the lungs, and vaping liquids contain several substances that can be potentially harmful to both the heart and the lungs.
Do minors suffer the same health effects as adults who vape?
Minors actually suffer increased health risks because their tissue and their organs aren't as developed, which makes them much more susceptible to damage.
How could Logan Carter have died of popcorn?
The popcorn lung was caused by the inhalation of diacetyl in this case. The popcorn lung reduced the lung's capacity, which then triggered an asthma attack, which then triggered a heart attack, which ultimately led to his death.
Just to make this clear for the jury, Dr. Robinson, would it be possible for Logan Carter to have died from the asthma attack alone without the influence of vaping?
No, the asthma wasn't nearly severe enough to have been fatal on its own. The popcorn lung triggered the asthma attack, which then triggered the heart attack, and the popcorn lung also compounded the effects of the heart attack.
Thank you, Dr. Robinson. Thank you, Your Honor. I have no further questions.
Very good. Thank you, Ms. Gatto-Chow. Ms. Rupping?
Yes, Your Honor. Now, Dr. Robinson, you reviewed Logan Carter's toxicology report to make your conclusions, right?
Yes, I did.
And you found that the nicotine levels in his blood were consistent with someone who smoked 5 cigarettes a day over the span of 2 weeks, right?
Yes.
Now, for Logan to obtain these levels of nicotine absorption in his blood, he would have had to vape for hours a day, right?
That is correct, yes.
Now, in the course of conducting your autopsy, Logan Carter's parents talked to you about his medical history, right?
Yes.
And you used that medical history to make your conclusions.
I did, yes.
Now, you learned that Logan had recently been hospitalized for respiratory issues, right?
I did, yes.
Now, you don't know if those respiratory issues were caused by vaping, do you?
I don't know whether those specific respiratory issues where he was hospitalized could have been caused by vaping, but given the nearness of that hospitalization with his imminent death, it allows me to make the conclusion that it could have potentially been caused by vaping as well, but I can't definitely say that.
Dr. Robinson, to your knowledge, Logan Carter wasn't diagnosed with bronchiolitis obliterans when he went to the hospital.
Yes, that's correct as well.
Logan Carter also wasn't diagnosed with asthma.
No, he was not.
In talking to Logan's parents, you also found that after going to the hospital, he had a reoccurrence of symptoms, right?
Yes, I did.
Now, due to the levels of nicotine in his blood, you concluded that Logan Carter's death was attached to vaping, right?
Yes, I did.
So some of those symptoms could have included coughing
Yes.
and wheezing
Also, yes.
and chest pains, right?
Yes.
And you'd agree that Logan Carter would have felt that cough, right?
You would have, yes.
Logan Carter would have felt those chest pains.
Yes.
And Logan Carter would have felt himself wheezing, right?
You would have, yes. That's the result of a symptom.
Now, the medical findings that you discovered during your autopsy supported your conclusion that vaping was a factor in his death, right?
Yes, they did.
Now, your medical findings would be consistent if Logan Carter decided to vape himself to death, right?
That is correct, yes.
Your medical findings would be consistent if Logan Carter accidentally vaped himself to death, right?
That's also hypothetically correct, yes.
Now, Dr. Robinson, there's nothing in your autopsy that shows how Logan Carter got the vapes.
That's also correct.
For all you know, Logan Carter could have stolen the vape he used, right?
That's correct, although the amount of damage led me to believe that it had been ongoing for quite some time, so stealing those products isn't exactly a sustainable source of acquiring those products.
So it's your testimony that if Logan Carter stole a vape, he wouldn't have been able to use that vape excessively?
That is not what I had said. I was talking about the products that you use to vape.
But Dr. Robinson, you'd agree that Logan Carter's levels of nicotine absorption could have been the same if he had stolen the vape he used, right?
Objection, Your Honor. Objection, Your Honor, as to relevance. May I be heard?
Yes, go ahead.
Your Honor, relevant evidence has the tendency to make a material fact more or less likely. Your Honor, Ms. Rapping has already explained through her line of questioning that all this witness knows is what the information has been given to him through his autopsy and his toxicology report. Asking this witness whether things would change if Logan Carter had stolen the vape pen when he has no knowledge of this is not relevant in court today. It doesn't go to causation or breach of duty.
Response, Your Honor?
Go ahead, Ms. Rapping.
Your Honor, in today's case, the plaintiff is contending that a vape bought from Vicks Vaporium by Logan Carter was the vape that caused his death. I'm simply asking Dr. Robinson if Logan Carter had obtained that vape in any other manner, would his blood levels and the nicotine in his blood still remain the same? This is highly relevant in today's case and showing that even if Logan Carter used a vape, that vape could have been from another source and still caused the same damage to his lungs.
May I respond, Your Honor?
No, I'm going to rule at this point. Ms. Rapping, I take your point. You have your line of questioning is relevant to it. You are, I think, at a point where I'd urge you to move along pretty quickly from this, but I'll let you go just a little further with it.
Yes, Your Honor. Now, Dr. Robinson, nothing in your autopsy showed that the vape that Logan Carter used was in fact from Vicks Vaporium, right?
Yes, that's correct.
Now, you talked to your investigator in order to help your conclusions in today's case, right?
I do, yes. That is standard practice.
And you learned that there had been a vape found in Logan Carter's room when he died, right?
I did hear that, yes.
Now, you didn't conduct any tests on that vape, did you?
No.
So you don't know if that vape had ever been used, right?
I don't know that, no.
You don't know if that vape ever had vape liquid inside of it, right?
I also don't know for that specific vape. However, there was evidence to suggest that Logan was vaping.
But you don't know if Logan Carter was using that e-vape to vape, right?
No, I do not.
And you can't tell the jury that if that vape was used, what exact liquid was inside of it, right?
That's also correct.
Thank you. No further questions, Your Honor.
Thank you, Ms. Rapping. Ms. Gutterchow, anything further?
Yes, Your Honor.
Very good.
Dr. Robinson, Ms. Rapping asked you about some symptoms that Logan Carter may have experienced while he was alive if he had popcorn. Just to be clear, in your autopsy, did you find that Logan Carter had damage in his throat and windpipe consistent with repeated coughing?
Yes, I did.
Thank you, Dr. Robinson. Thank you, Your Honor. No further questions.
Very good. Thank you, Ms. Gutterchow. The plaintiff may call their next witness.
Your Honor, at this time, the plaintiff rests.
Plaintiff rests. The defense may call its first witness.
At this time, the defense calls Kennedy Womack to the stand. Ms. Womack, I'd like to remind you that you're under oath. Please tell the jury your full name.
Kennedy Grace Womack.
Ms. Womack, today's case involves the death of Logan Carter. Did you know Logan?
Yes, I did.
And how did you know Logan?
Logan is, sorry, Logan was my nephew, but he was more like a younger brother to me.
If Logan was like a younger brother to you, how often did you see him?
Oh, all the time. I joked that I was basically like a nanny to Logan and Preston. I fed them, clothed them, gave them checkups when they needed.
Ms. Womack, you said you gave the boys checkups. Can you explain what you mean?
Right. I'm an ICU nurse down at the Milton County Medical Center. So whenever the boys had any mysterious bumps, a sore throat, or spiked a fever in the middle of the night, Tristan and Nick would call me.
Could you tell us a little bit more about your relationship with Logan?
Sure. Logan and I really understood each other, you know? He could talk to me about anything, video games, soccer matches, girls even. I miss him.
We've heard testimony today about Logan using vaping products. Were you ever made aware that Logan was using these products?
Unfortunately, yes.
When did you first find out that Logan was vaping?
It was early February. I found out that Logan had gotten suspended from school for vaping in class.
How did you respond to Logan being suspended for vaping?
I was shocked.
Why?
Like, I've been there, done that, smoked a cig or two in high school, but I knew it wasn't like Logan to be doing illegal stuff like that. And at school?
We heard earlier from Tristan Carter that you had a conversation with Logan after he got suspended. Is this true?
That is true.
And what did you tell Logan in this conversation?
I told him how stupid it was to vape, and I lectured him about the dangers of it. I told him about the stuff I see every single day working at the ICU. People who vape, who are struggling to breathe on ventilators, have permanent lung trauma, damage to their bronchial trees. I told him that this juice that he was putting in his body produces the same nicotine addictions as cigarettes and does similar things to your lungs as well.
How did Logan respond to you explaining the dangers of vaping?
Logan looked at me and he told me that he understood. That's what kills me about this whole thing. He understood what he was doing and he did it anyways.
Ms. Womack, after you learned that he was caught at school in February of 2020, did you notice a change in Logan's behavior?
Yes, I did.
What did you notice?
Logan was just low energy and he looked worn down all the time. And then that cough started.
When exactly did this cough start?
A few weeks after his suspension, so in March.
Could you describe this cough for the jury?
Oh, it was this awful, deep, phlegmy chest cough, and he just looked so sickly and small, like he wasn't eating or something.
Ms. Womack, did Logan ever seek medical care for this cough?
Yes, they entered him at Children's on March 16th.
Did you see Logan after he was released from the hospital?
I did.
Was his cough gone?
Yes, but not for long.
What do you mean?
I thought he was going to be fine. But about a week later, that cough was back and he just sounded awful, just like before, except he was wheezing. And then just like that, he was gone. And it was right in front of us the whole time.
What was right in front of you?
The vape. I couldn't believe I found it in his bedroom.
You said you found this vape in Logan's bedroom. When did you find it?
After he died, I went through his room. Tristan couldn't bear to do it.
I'm now showing you what has been previously marked and entered as Exhibit 3. Is this a picture of the vape you found in Logan's room?
Yes, this looks like the one.
And where in his room did you find this vape?
I found it in his desk drawer. After I had told him the risks, after he'd been thrown out of school, after he spent days in the hospital on steroids struggling to breathe, I found this vape in Logan's desk drawer.
Thank you, Ms. Womack. No further questions, Your Honor.
All right. Thank you, Ms. Weiner. Ms. Corey?
Ms. Womack, you agree with us that vaping can lead to health problems, right?
I do. I'm an ICU nurse. I see the damage that vaping and smoking does to people's lungs every single day.
Right. You get a close look to the lung trauma that vaping can cause.
Exactly right.
So if someone were to say that vaping was a safer alternative to smoking, in your opinion, that would be false, right?
I wholeheartedly disagree with that statement that vaping is a safer alternative to smoking. It causes the same nicotine addictions as cigarettes in some cases, and it can do similar things to your lungs.
Now, you also believe that vape companies appeal to children through their advertisements.
Objection, Your Honor. Pursuant to Rule 701, Ms. Womack is a lay witness, and she has no rational perception to the goals or how the tobacco industry markets. She doesn't work in the tobacco industry. She's not a professional in marketing. She's a nurse. She has no firsthand rational perception on how the tobacco industry markets.
Your Honor, may I respond?
Go ahead, Ms. Corey.
Your Honor, this witness does have firsthand knowledge as to how the vaping industry markets, as she had conversations with Logan and testified herself to seeing vape ads. This is well within the scope of her personal knowledge and simply calls for an opinion, not expert testimony in the field of advertising for vape companies.
May I be heard, Your Honor?
You may, Ms. Weiner.
Ms. Womack can testify to the ads she saw pertaining to what Logan saw, but she cannot testify to the goals of the tobacco industry and their marketing tactics. That would require an expert or someone in the field of tobacco marketing. She does not have a rational perception to testify to what the tobacco industry is trying to market to.
May I respond, Your Honor?
I'm going to overrule the objection. You may proceed.
Yes, Your Honor.
Ms. Womack, you believe that vaping companies appeal to children through their advertisements and flavors, right?
Big tobacco as an industry does do that, yes, which is exactly why I made sure to communicate to Logan the risks associated with these companies.
I'd like to walk through those one by one. Now, you noticed that most vaping ads are found on social media, right?
I haven't seen a ton of ads on social media, but some, I guess, can be put on social media.
You've noticed that most social media users are teens or young adults, right?
I don't think so, no. Anybody can be on social media.
Well, you've noticed that vaping companies flood teens' social media pages with ads, right?
They can.
Now, you've also noticed that vape companies have cloud watching shows, right?
I've heard about them before, yes.
These are shows where minors can go watch adults vape, right?
At times they can. It's ridiculous.
Exactly. You yourself believe that these cloud watching shows groom children into believing vaping is fun, right?
Exactly. This is exactly why I warned Logan exactly what he was being put against. Exactly this information so that he would know not to take this risk.
You believe that these cloud watching shows destigmatize vaping products entirely, right?
Exactly.
Now, you've also noticed that vaping companies promote their products in a way that could appeal to children, right?
They can.
And you yourself believe that this is through their candy flavors, right?
Yes, they can do that sometimes. Again, I told Logan about the risks associated with this so that he would be prepared to not make the decision to vape.
Yes, and you believe that these candy flavors don't appeal to adults, right?
Not necessarily that they don't appeal to adults, but they sometimes can appeal to children.
Exactly. You believe that these candy flavors can appeal to children, right?
Right.
These are candy flavors like mango mint, right?
That's could be a flavor they promote. I'm not sure exactly.
Even Skittle flavored vapes, right?
I've seen it.
Now, you found Logan's vape pen, right?
I don't know if it was Logan's, but I found a pen in his room, yeah.
Ms. Getz, could you screen share Exhibit 3 as it's already been entered into evidence? You found this, like you said on direct, in Logan's desk drawer, right?
I couldn't believe I found it in his desk drawer after all that I'd told him.
And you ran the serial number on this pen through the eVape verification site, right?
That's right.
Would you recognize a picture of that verification site if I were to show it to you today?
I'm sure I would.
Ms. Getz, could you screen share Exhibit 5 constructively out of the presence of the jury? Now, Ms. Womack, this is the eVape verification site you went to, right?
Yes.
Does it look like a fair and accurate screenshot of the device verification page you saw?
Yes.
Your Honor, at this time, the plaintiff offers Exhibit 5 into evidence.
Very good. Any objection, Ms. Weiner?
Yes, Your Honor. Two objections. First, pursuant to Rule 49, lack of foundation to whose website this is, how it works, and how Kennedy would know that the information on it is true. Opposing counsel has not laid foundation to that. And secondly, pursuant to Rule 801, statements on this website are hearsay. The statement of sold by Vicks Vaporium is an assertion, and there's an assertion from Kennedy of the serial number typed in on the website.
Your Honor, may I respond?
Please do.
Beginning with the stipulation 49, as to lack of foundation, Your Honor, this witness just testified that she went herself to the eVape website, where the pen itself she believed was bought. The eVape logo is on this website and is also on the pen. As for foundation as to how this is related to Vicks Vaporium, we know that eVape is closely related to Vicks Vaporium. And so the foundation for this website has already been laid. Secondly, as for the hearsay objection, as eVape and Vicks Vaporium are closely related and our products that we saw on their advertisements are sold at Vicks Vaporium, this is a statement by the party opponent and is not hearsay.
May I respond?
Yes, Ms. Weiner.
Your Honor, no foundation has been laid that this is Vicks Vaporium's website or a statement by Vicks Vaporium. Nowhere on this advertisement does it say that Vicks Vaporium is involved with the website and therefore cannot be an opposing party's statement pursuant to Rule 801 D2A. Furthermore, opposing counsel still hasn't laid the foundation pursuant to Rule 49 that Ms. Womack has knowledge of exactly how this website works.
Your Honor, may I respond?
You may, Ms. Corey.
Your Honor, eVape is an employee or a close associate of Vicks Vaporium. And so under this umbrella, they fall into the scope of party representatives, opposing parties barred from hearsay. And so this is a statement made by the party opponent. As for the foundation, we have laid foundation by walking you through where this pen was sold and who sells this product. The consistency in the logo and the mentioning on the ad, the pen, and the website here indicate that this is in fact an eVape website closely related to Vicks Vaporium.
All right, Ms. Weiner.
Yes, Your Honor. Not only has opposing counsel not laid the foundation through Ms. Womack that Vicks Vaporium knows about this website or is closely related to this website, the assertion from Kennedy Womack is still violates the hearsay rule. It's an assertion by Kennedy when she typed in the serial numbers, and that does not fall under rule exception 801 D2A.
All right, thank you, Ms. Weiner. The objection is overruled. Exhibit 5 is admitted.
Yes.
Ms. Womack, you entered the serial number on the vape pen that you found, right?
Yes, into this website.
And you saw that that exact vape pen was sold from Vicks Vaporium, right?
Yes. The serial is matched up.
Thank you, Ms. Getz. You can stop screen sharing at this time. When you went through Logan's room, you also found a receipt, right?
I did.
And that receipt was from Vicks Vaporium.
Objection, Your Honor. Pursuant to Rule 1002, best evidence, opposing counsel cannot discuss the contents of a document or exhibit without producing it in court today.
Your Honor, may I respond?
Well, let me read that rule. All right, go ahead, Ms. Corey.
Your Honor, we're not going into the contents of this receipt. We're not going to talk about what was bought on this receipt, the credit card used, or even the date. And so we're not going into the contents of this receipt, but rather the name which was indicated on it. And so this does not fall under Rule 1002 as best evidence for lack of a document.
May I respond, Your Honor?
You may.
Your Honor, Ms. Corey just said that she's going to use the contents of the receipt, the fact that it was from Vicks Vaporium, when discussing the receipt. And pursuant to Rule 1002, she has to produce the original to prove its contents.
Your Honor, may I respond?
Well, actually, I'm just rereading the rule. And what it says is copies of any case materials, including a large format exhibits, are considered as original. So I read that to suggest that what we have you haven't proffered it yet, so I don't have the number in front of me. But I believe there is such a document in the materials, and it is identified as an original or is equivalent to original by this rule. So that objection's overruled. You may proceed.
Your Honor, may I be heard?
You may.
Your Honor, this receipt is not an exhibit and cannot be entered into evidence. So pursuant to the best evidence rule, opposing counsel cannot discuss its contents. She has to bring it into evidence in order to do that.
You may be.
Your Honor, may I respond?
Yeah, and I may, Ms. Weiner may be correct. I was thinking that there was an well, it would have to be Exhibit 4 because Exhibit 6 is the newspaper. It's Exhibit 4, 6. All right, Exhibit 6. Oh, Exhibit 6 is that. All right. Yeah, I was mistaken. I was thinking that there was an exhibit that was in the materials. So you don't have the document itself. So educate me in that regard.
Your Honor, may I respond?
Please.
We assert that we don't have the document in court today. It wasn't included in the mock trial package. However, we're not using we're not going to go in depth as to the contents within this document, which would understandably fall under Rule 1002. Rather, we're simply asserting that Ms. Womack found this document and through her observations, what she perceived once she saw it. We're not going to go into any depth about the credit card use, the dates, the products, or any kind of content like that.
May I be heard, Your Honor?
You may.
Your Honor, calling the receipt a receipt from Vicks Vaporium is going directly into the contents of the receipt. The receipt has to have said Vicks Vaporium for Ms. Womack to make that conclusion that it's from Vicks Vaporium. And pursuant to Rule 1002, that falls under the contents of an exhibit which opposing counsel cannot enter into evidence. She can call it a receipt, but she cannot characterize it as a receipt from Vicks Vaporium.
All right. Ms. Corey, you may respond.
Your Honor, I'm simply reiterating that this is not to prove the contents within what were bought on this receipt or what was acted when in Vicks Vaporium, but rather the observations that Ms. Womack made herself, the conclusion that she drew herself from her own personal perspective. And we're not using the contents of the document to prove a truth of a matter asserted of the products bought or any details of such.
Well, the relevance, I'm going to sustain the objection. I think the relevance of the receipt is that it proves something about the purchase of the item. And Rule 1002 does impose a the best evidence rule requirement that excludes her just describing what she can see. If we could see it, the other side might have a way to show that it doesn't really say that. So objection sustained. You may proceed.
Yes, Your Honor.
Ms. Womack, you learned that the vape pen that was found in Logan's desk drawer was bought from Vicks Vaporium, right?
Right. I couldn't believe Logan took that risk and continued to vape even after I told him about the dangers of it.
So that's a yes to my question?
Yes.
Thank you, Ms. Womack. Thank you, Your Honor. I have no further questions.
All right, thank you, Ms. Corey. Ms. Weiner, redirect.
Yes, Your Honor. Ms. Womack, on cross-examination, Ms. Corey asked you about how the tobacco industry markets to teens. Can you explain how this impacted your conversation with Logan?
I'm no friend of Big Tobacco. I'm an ICU nurse. Big Tobacco's been doing this for 200 years, lying to people, poisoning people. So I had to let Logan know what the deal was, with knowledge, with information, with a warning, so that he knew the risks and so that he wouldn't feel the risks later. And I can't believe he ignored them.
Ms. Womack, opposing counsel also asked you about a verification page that you used to determine that the vape you found in Logan's room came from Vicks Vaporium. I'm now screen sharing what has been previously entered as Exhibit 5. Ms. Womack, from this website, did you learn who bought a vape from Vicks Vaporium?
No, it just says who it's sold by.
Thank you. No further questions, Your Honor.
All right. Will this witness be excused?
Yes, Your Honor.
Yes, Your Honor. I have nothing further as well.
Very good. The defense may call their next witness.
The defense calls Joseph Camille to the stand. May I proceed, Your Honor?
You may.
Please tell the jury your full name.
My name is Joseph Camille.
What is your occupation?
I'm a public relations representative at Maurice Phillip. That means I represent our brand to the public, communicate our mission to clients and vendors, as well as do some advertising.
And what is Maurice Phillip?
Maurice Phillip, we are one of the world's largest tobacco companies. We produce tobacco products and tobacco alternatives like e-cigarettes, more commonly known as vapes. Maurice Phillip puts the class within your grasp.
What part of Maurice Phillip do you work in?
Back in 2016, I was assigned to the e-vape acquisition rollout, and I've been working with this product ever since. I'm the brand manager for the e-vape social media, and I also do some marketing and advertising.
Could you elaborate on the advertising aspect of your job?
Of course. I help promote our product, but more importantly, our mission to the public.
And what is e-vape's mission?
Thank you for that question, Counselor. E-vape was designed to get adult tobacco users to switch to our product, a tobacco alternative. We believe it as a safer alternative to traditional cigarettes.
You mentioned the e-vape. Please explain this product.
Absolutely. The e-vape is a small cigarette-shaped device which can vaporize a liquid that the user can inhale. By itself, it's just a hollow tube with some electronics, basically. It's our vaping liquid, which makes this an e-cigarette. This liquid doesn't contain any of the harmful chemicals found in cigarettes, which make them so dangerous.
Did Maurice Phillip create the e-vape?
No. Our flagship level partner, dare I say, the key to Maurice Phillip's success, Mrs. Vicky Vaverick, created our product. We bought the rights from her back in 2016.
Where's the e-vape sold?
The e-vape is sold in convenience stores and smoke shops across the country, including our flagship level stores like Vicks Vaporium.
What is a flagship level store?
Our flagship level stores are our most important, most profitable stores. They model the success of Maurice Phillip, and they also model the guidelines and legal regulations that we follow.
Do you interact with Vicks Vaporium?
Somewhat. Look, Ms. Vaverick runs the store. She's in charge of all the day-to-day activities, but we own the e-vape brand. We're in charge of advertising.
Mr. Camille, You mentioned earlier that the e-vape is designed for adult tobacco users. How does this specific demographic affect sales?
Well, that demographic is where most of our profits come from. It's where we focus our time, our money, our energy. This group of people is already addicted, already uses nicotine, so it's an easy switch for them.
You said this demographic is people who are already using nicotine. Do the e-vapes contain nicotine?
Yes, our e-vaping liquid can contain nicotine.
Are there guidelines regarding vaping products that stores like Vicks Vaporub have to follow?
Guidelines? A bit more than guidelines. Yes, the law. This means not advertising to minors, checking IDs when needed, selling to people clerks reasonably believe are 18, and having a warning sign posted outside of your store.
Does Maurice Phillip follow the laws governing vaping products?
Absolutely. And we expect the same from our flagship level stores, including Vicks Vaporub.
Mr. Camille, some say businesses like yours put profits over people. But what is Maurice Phillip's priority?
It's simple. For a company, we try to be successful, and selling to minors loses us money. Just look at Juul. They're millions deep in lawsuits from selling to minors. It's defending the indefensible. I bet their PRs must be tired of appearing in court every other day.
Does your company put warnings about nicotine to make sure customers know the risks?
Yes, our website always has a nicotine warning at the top to make the addictive nature of nicotine an obvious risk.
I'm now showing you what has been previously entered as Exhibit 5. Can you read the warning listed at the top of this verification form?
Warning, this product contains nicotine. Nicotine is an addictive chemical.
And can you read the warning listed at the bottom of this verification form?
Sale of tobacco products to minors is prohibited by law.
Mr. Camille, how do customers receive this verification?
After an e-vape is sold, customers can go to our website and verify that their product was genuine.
Why do you put these warnings?
We put these warnings out of an overabundance of caution to make sure that everyone who's using our product is aware of its nicotine content and the risks associated with that. It's also another warning for people who just shouldn't have their hands on our products, like children.
How much control do you have over the advertisements for the e-vape?
Complete control. It's our product, our ads. We create the ads, we place the ads, we post the ads. We control all parts of our advertising.
Now, you've told the jury that your target audience with advertising is people who are not underage, adult tobacco users. Do you remember making an advertisement specifically for Vicks Vaporub?
Of course.
I'm now showing you what has been previously entered as Exhibit 7. Did Vicks Vaporub have any control in making this advertisement?
Timekeeper, stop time. Mr. Lascelles, are you there?
I believe, yes.
Okay, go ahead. I'm sorry. Go ahead, timekeeper.
Yes, Your Honor. Did Vicks Vaporub have any control in making this advertisement?
Not at all. Under our patents and trademarks deal, they put their name on it because they're a flagship level store, but Maurice Phillip is solely responsible for the creation and placement of this ad.
Thank you, Mr. Camille. No further questions, Your Honor.
All right. Thank you, Mr. Mayette. Mr. Joseph.
Yes, Your Honor. Cross-examination?
Yes, sir.
Now, Mr. Camille, you said that Maurice Philippe handles the advertising for Vicks Vaporub, right?
Of course. We have complete control. It's our ads, our product.
Well, Ms. Getz, could you please screen share Exhibit 3? It's been previously entered into evidence. I'm sorry, Exhibit 7, the advertisement. Thank you, Ms. Getz. And now, Mr. Camille, just to make it absolutely clear to the jury, that says Vicks Vaporium right there, right?
Of course, it's our ad. We know that Vicks Vaporium is a flagship level retailer in Miltonville.
And just
That's why we put their name on our ad. It's our ad.
And just to make it clear to the jury, that also says sponsored by Vicks Vaporium too, right? At the
Yes,
top
it does. But again, yes. But again, our ad.
And just to make it clear to the jury, this is an ad detailing products sold at Vicks Vaporium, right?
I believe it's an ad e-vape.
And e-vape is sold at Vicks Vaporium?
Yes.
Okay, thank you, Ms. Getz. You can stop screen sharing. Now, Mr. Camille, I want to talk about the real reason you're here in court today. You actually have a stake in this case, don't you?
Not real. I don't have a personal stake in this case,
Well,
and I'm not being paid. Should I finish?
Yeah, sorry about that. There is just a bit of audio cutting out.
Of course, I don't have a personal stake in the case, and Maurice Philippe doesn't have much of a stake either. We've existed long before Vicks Vaporium, and will exist long after. I'm just here to tell you the truth.
Well, your whole job is to promote vaping companies, right?
My job is to promote my company and my product, the e-vape.
And your company sells vaping products, right?
Of course, we sell our flagship, our signature vaping product, the e-vape.
Exactly, and Vicks Vaporium is one of your biggest e-vape clients, right?
They're our flagship level store, yes.
They've been the key to Maurice Philippe's success in the vaping industry, right?
Of course, Ms. Vape created our product in the end.
Exactly, they even created e-vape to begin with, right?
Yes, we bought the rights from them.
So if Vicks Vaporium were to be held liable for a child's death, that could also make your company look bad too, right?
Of course, it would be a PR disaster, a career suicide for me.
Exactly, Mr. Camille, and bad press could lead to fewer customers, right?
I mean, of course, that's how business works, but wouldn't honestly affect us that much. Of course, it'd be a disaster.
And fewer companies and fewer customers could mean less money, right?
That's how business works.
Is that
That's
a yes?
why we don't. Yes, that's why we don't sell to minors. We don't want to be another Jewel.
Well, now I want to talk about your bias against families like the Carter family.
Objection, Your Honor. Opposing counsel is testifying with that statement.
Your Honor, may I respond?
That was just a transitional statement. I presume that there'll be some relevant questions. You may proceed.
Yes, Your Honor.
Your Honor, I would argue that that is more prejudicial than probative under Rule 403, and I would move to strike the statement.
Your Honor, may I respond?
I've already ruled you got some leeway for transitional statements. That was short enough to be all right. You may proceed.
Yes, Your Honor.
Well, Mr. Camille, you think that people who sue vape companies should just accept a settlement and move on with their lives, right?
No, we settle because we believe it to be a better solution for the families. These families have already gone through so much, and we believe that instead of having their lawyers drag them through weeks, months of court, we just offer them a settlement right away so they can move on with their lives.
Is it your testimony in court today that you don't think families should accept a settlement and move on with their lives?
I think we offer our settlements because we believe it to be a better solution for our families so they can move on with their lives.
So that's a yes to my question, Mr. Camille.
Yes.
You think that most lawsuits against vape companies are baseless, right?
Not most, but many.
Okay, Mr. Camille. Well, you think that families who sue the tobacco company are just exaggerating facts and complaints, right?
Well, you see what these attack dog lawyers are trying to do. They just aren't trying to work. They just want to bankrupt us.
So is that a yes to my question?
Yes.
And you think that plaintiff lawyers like myself and my co-counsel are just here to bankrupt your companies, right?
No, my company is not on trial here.
vape companies.
You are a lawyer in this case. This case does not involve any vape companies.
Well, Mr. Camille, vape companies are the defendant, right? We're in court today talking about a vape company, right? A vape company.
This case, no. We're today in court. The defendant today, vape shop. There's no vape company on trial today.
Your Honor, I'm sorry. I can't hear the witness. The audio is cutting out a bit. I just asked that we stop the time and see.
Stop time.
Sorry about that, Your Honor. I just wasn't able to hear his answer.
All right. Yeah, it distorted a little bit for me as well.
Should I restate the answer?
Yeah, I hear you now. Mr. Joseph, do you hear him?
Yes, Your Honor. It's just cutting in and out a bit. It's just kind of hard to hear everything he's saying.
Okay.
I try my best.
All right. I guess we just have to go ahead. Restart time, please.
Yes, Your Honor. Mr. Camille, I'll re-ask my question. You think that people who sue tobacco companies exaggerate facts and complaints, right?
Yes, they try and suck us dry.
Exactly. That would be families like the Carter family, right? They're suing a tobacco company.
We've already settled with the Carter family.
Well, Mr. Camille, I wasn't asking if you've settled with the Carter family. I was asking whether or not they're suing a vape company.
Not currently, because we've already settled with them.
Mr. Camille, you're aware you're testifying in court right now, right?
Yes, I'm testifying in a trial where the defendant is a vape shop owner, not that makes vaping products.
I'm sorry, Mr. Camille. The end of your question cut out. The end of your answer cut out.
Please repeat the last sentence, Mr. Camille. Mr. Wilson. I think
today.
Stop time. Guys, add on another 10 seconds if you can. All right, Mr. Lascelles, I think we've got you again. Repeat, I'd like you to start back up from answering your question about vape companies and vape shops.
Of course.
Oh, and yeah, it has been suggested to me that one technique that often works when these things break down is if you turn your camera off, we can probably hear you better. So do that if you please.
Okay. Yes, today the defendant, there's no vape company on trial. No company that produces vapes is on trial today.
Okay, Mr. Camille. Well, you think that lawsuits against vape companies are just a way for plaintiffs to cash in and get a windfall, right?
Yes, they try and suck the money out of us.
Thank you, Your Honor. I have no further questions. And I just ask that we have around 20 or 30 seconds added to our time just because of the technical difficulties experienced this cross-examination.
Yeah, so ordered. Timekeepers, give them another 30 seconds.
Thank you, Your Honor.
Add back on. All right, Mr. Mayat.
Yes, Your Honor. My co-counsel is now, or my screen share is now going to pull up Exhibit 7, Mr. Camille. Opposing counsel asked you if this advertisement was made by Maurice Phillip or Vicks Vaporeum. I want to be clear. Did Vicks Vaporeum have any role in the creation or placement of this advertisement?
No, it's our ad.
Thank you, Mr. Camille. No further questions, Your Honor.
All right, thank you, Mr. Mayat. The defense may call their next witness.
At this time, the defense calls Vicky Vavrick to the stand. Please introduce yourself to the jury.
My name is Vicky Vavrick, and I'm the owner of Vicks Vaporeum.
What is Vicks Vaporeum?
Vicks is a smoke shop I established back in Miltonville in 2010. I was lucky enough to snag a great spot for the Shaw. Word got around about my products, and eventually we were able to expand.
And why did you start the Vaporium?
Ever since I was little, I'd always dreamed of being my own business owner. The next Sarah Blakely. My parents were smokers, so I thought, what better industry to enter into? It only felt right to start my own company.
So what do you sell at Vic's Vaporium?
We sell an assortment of tobacco and nicotine products, electronic cigarettes, pipes, lighters. It's everything a smoker could ever really ask for. In fact, we are the flagship retailer of the e-vape, my own personal invention.
And what's the e-vape?
The e-vape is a unique device, an electronic cigarette, where users can inhale flavored smoke. I invented it in 2015, although I no longer have ownership of the product.
Now, could you explain how the e-vape works?
Yes, it's essentially a vaporizer, but the e-vape itself is like an empty tube. The user can insert any juice they would like.
Ms. Weaver, do you know of any risks that come along with the e-vape products that you sell?
Yes, these products contain nicotine. In fact, we are required by law to post warnings informing our customers just that.
Ms. Weaver, you mentioned earlier that you no longer have ownership of the e-vape. What did you mean when you said that?
I sold my rights to Maurice Phillip in 2016. They control everything from the advertising to the manufacturing. It's really not even my product anymore.
Ms. Weaver, could you please walk the jury through the process of purchasing products at Vic's Vaporium?
Sure. So a customer will approach our clerk with the product they wish to purchase. The clerk will ask for some form of identification that proves that the customer is over the age of 18. If this identification is understood to be authentic, then we are free to sell. If not, the customer is asked to leave the property immediately. We have a no tolerance policy for selling to minors.
And why do you check the IDs of your customers?
Under the law, we are required to check the ID of anyone we have reason to believe is under the age of 18, but because of our legal obligation to not knowingly sell to minors, we aim to check every ID.
Your Honor, before I proceed, I just wanted to make sure you were there. You disappeared from the screen.
Yeah, I did freeze up for a moment. That's why I turned it off, but I seem to be all, well, I'm getting a warning, but so I'm going to turn my screen off for a moment, but I am still here.
Yes, Your Honor.
Go ahead.
Ms. Weaver, would there ever be a situation where you wouldn't check a customer's ID?
Yes, we have customers come into our store anywhere from 2 to 4 times a week. Once we've carded them multiple times and established that they're over the age of 18, there's no further need for identification. These customers then become regulars.
So why does your store have to follow the regulations that you just talked about?
In this industry, I stand out, so there is no room for error. I mean, selling to minors is simply bad business. We'd get bad press, which would lead to us losing customers.
And you told the jury about how customers must show proof of age. What do you as the seller have to do to ensure that your customers know the risks of the products that they purchase?
We are required to post warnings concerning the age at which these products can be purchased. My store posts warnings throughout our store, on our storefront. They're practically impossible to miss.
Now, the plaintiff is claiming that Logan Carter got an e-vape from your store. Do you know how a minor could get a hold of your products?
Yes, the 2 ways I can think of include fake IDs and then dealers, where minors will ask those who are of legal age to make purchases on their behalf.
And what do you do as Vic's Vaporium to ensure that you follow the law of not knowingly selling to minors?
My clerks are trained and required to check customers' IDs. I have full confidence that my clerks are trained to the best of their abilities to not only scout out fake IDs, but to verify customers' ages.
And Ms. Weaver, to your knowledge, did any of your clerks ever sell vaping products to Logan Carter?
No.
To your knowledge, did any of your employees ever fail to check Logan Carter's ID?
No.
And to your knowledge, did your employees ever sell to Logan Carter knowing he was a minor?
Absolutely not.
Thank you. No further questions, Your Honor.
All right, thank you, Ms. Rapping. Got a shot. You may proceed.
Yes, Your Honor. Ms. Vavrick, your store has sold to customers with fake IDs in the past, right?
No.
Well, I actually want to talk about one of those instances in which that actually happened. In 2020, undercover police officers came into your store with fake IDs, right?
That is correct.
Your Honor. Objection pursuant to Rule 404. This is improper character evidence. Opposing counsel is attempting to use past acts of Vicks Vaporium to show propensity, and that because they possibly sold to people with fake IDs in the past, then in today's case they acted in propensity by completing the same action, which is inadmissible under Rule 404.
May I respond, Your Honor?
You may, Ms. Getachel. What is the permissible purpose for which you seek to introduce this evidence?
Yes, Your Honor. Under Rule 406, evidence of an organization such as Vicks Vaporium's routine practice is admissible to show conduct in conformity with that routine practice. Your Honor, Ms. Rapping herself entered evidence of Vicks Vaporium's routine practice in her direct. When she asked this witness about the age security protocols of Vicks Vaporium, she was using that evidence to prove conduct in conformity with that routine practice. To prove that in the case of Logan Carter, their employees thoroughly checked his ID and did not know that he was a minor. Your Honor, we've shown through our case in chief, through the testimony of Devin Andrews, that she and Logan Carter purchased from Vicks Vaporium with fake IDs numerous times. If I were to continue this line of questioning, I will show evidence of other instances in which the employees at Vicks Vaporium, an organization, did not have a routine practice of thoroughly checking the IDs of their customers. Your Honor, this is admissible as under Rule 406. I'm using this evidence not to attack the character of Ms. Vaporium, but rather to show that her organization, Vicks Vaporium, had a routine practice of not thoroughly checking the IDs of their customers, which is admissible under Rule 406. And again, Ms. Rapping herself entered evidence of a routine practice of Vicks Vaporium in her own direct.
Your Honor, may I respond?
You may.
Your Honor, first, on the first hand, under Rule 406, opposing counsel would have to be establishing a routine practice. She simply established one incident. She's attempting to establish one incident of Vicks Vaporium selling to people with false identifications, which is not a routine practice of her business. Furthermore, in order for 406 to apply to make this admissible, it has to meet 404. Opposing counsel has not addressed that this is still character evidence being used to show propensity, that Vicks Vaporium acted in accordance with the same traits that they would have acted with when they sold to people with fake IDs in the past.
May I respond, Your Honor?
Well, I'm going to rule in your favor. The objection is overruled. Ms. Rapping, I believe you did introduce this topic generally. So Ms. Getachel may cross on it.
Yes, Your Honor. I'll ask the question again, Ms. Vapor. In 2020, undercover police officers came to your store with fake IDs, correct?
Yes, they were attempting to deceive my clerks.
And they succeeded in deceiving your clerks, correct?
Yes, but due to the mask mandates, it was becoming exceedingly difficult to verify the face with the IDs.
Well, I actually want to talk about that. Now, you'll agree with me that there are ways of checking if an ID is fake besides checking to see if the faces match, correct?
Yes, of course.
You'll agree with me that a government issue ID is going to have a different quality than a fake ID, right?
Yes, it can.
You can hold an ID to a light and see if the hologram is there to see if it's real, right?
Yes, that's one method.
You'll agree with me that if there are any mistakes on the ID, that could indicate if the ID was fake.
Yes.
But despite all of these different methods, your employees did not detect that these IDs were fake, right?
Right, and as I said, these IDs were passable IDs that were presented by the police.
Now in 2019, you were charged with the sale of tobacco products to minors, right?
Yes.
You would recognize a copy of your conviction?
Yes, I would.
Ms. Getz, could you please screen share Exhibit 5? Excuse me, Ms. Getz, I need to please screen share Exhibit 6. Exhibit 6, Ms. Getz, I apologize. Your Honor, can we pause the time on my screen? Oh, never mind, Your Honor. Can you go to the second page, Ms. Getz? You'll agree with me that this is a copy of your conviction?
Yes, it is.
It's an accurate copy?
Yes.
Your Honor, the plaintiff offers Exhibit 6 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 6 is admitted.
You'll agree with me that you pled guilty to the sale of tobacco products to minors, right?
Yes, I did.
Thank you, Ms. Getz. You can stop screen sharing that document. Ms. Faberg, you'll agree with me that in 2019, the age to purchase tobacco products raised from 18 to 21, right?
Objection, Your Honor. Under Rule 403, testimony about the age change of the age someone has to be to obtain nicotine products is confusing the issues for the jury. In today's case, in the complaint, the plaintiff has contended that Vicks Vaporeum breached their duty by selling to someone who was under 18, meaning they breached the Georgia statute. The federal age change of 21 is federal statute. Therefore, testimony about that age change is confusing the issues to the jury, because in today's case, we are simply talking about the statute in Georgia law that the person who purchases the products must be over the age of 18.
May I respond, Your Honor?
You might as good, John.
Your Honor, this law did apply in Georgia. In fact, in this witness's affidavit, she specifically said that due to this age change, it lowered her market. And that meant that she had to continue selling products to customers that were 21 and over instead of 18 and over. Your Honor, this did apply to this witness's store. She specifically says in her affidavit that this age change lowered her market.
Response, Your Honor?
Briefly.
I don't disagree that the age change applied to Vicki Vavrick's store, but rather in today's case, we are here in state court, not federal court. Therefore, we are arguing the breach of the duties of her state requirement, not to knowingly sell to a minor under the age of 18. That statute about the age of 21 is a federal statute. Therefore, it's confusing the issues for the jury because in today's case, in the complaint, the plaintiff contended that Vicks Vaporeum breached their duty by violating the statute, the Georgia statute, that the customer was under 18.
May I respond, Your Honor?
You may.
Your Honor, we are using this evidence to show that because Ms. Vavrick had to accommodate this age change, that it lowered her market. And that by lowering her market and with less customers, she made less profit. Your Honor, this goes to the motive of Vicks Vaporeum to be motivated not to routinely check the IDs of customers. As if they were selling products to minors, they would make more money to accommodate that lower market that they experienced due to the fact that the age change lowered their market and may cause them to have fewer customers. This is relevant and it makes a material fact more or less likely because it goes to the organization's motive for not routinely checking or not thoroughly checking the IDs of its customers, as that would make them more profitable.
All right, I'm going to overrule the objection. I think Ms. Gutachaz identified a relevant line of inquiry, and this is something that is not so far afield that I'll let her present the case that she wants to present. Go ahead, ma'am.
Yes, Your Honor. You'll agree with me, Ms. Vavrick, that this age change lowered your market, right?
Yes, it did.
You'll agree with me that with fewer customers, you make less profit, right?
Yes, that is how it works.
Now I want to talk about the cloud chasing events you host at your store. Now these are events in which adults vape in large amounts for entertainment, right?
Yes, they're competitions.
You'll agree with me that minors are allowed to be present at these events.
Yes. But minors are not allowed, excuse me.
I didn't mean to interrupt you, Ms. Vavrick.
Minors are not allowed to participate in the event, and nor are they allowed to purchase any products.
But that's a yes, they're allowed to be present while adults vape in large amounts for entertainment, right?
Yes, I cannot regulate who watches these events.
You say you can't regulate who watches these events, but you'll agree with me that you host these events in areas that could be open to the public, right?
Yes.
Now, if you chose to hold these events on private property, you could ask minors to leave, right?
Yes.
But you host these events in areas where minors would be allowed to watch, right?
Yes.
Now I want to talk about social media advertising of Vicks Vaporeum. Ms. Getz, could you please screen share Exhibit 7? Now I want to make something clear, Ms. Vape. Maurice Philly bought the rights of eVape, right?
Yes, that is correct.
It did not buy the trademark for your store, Vicks Vaporeum, correct?
They did. They used my name to advertise their products. Yes.
But you'll agree with me that you still own the rights to Vicks Vaporeum.
I still own the store and I get to use the name. Yes.
So they have control over eVape, but you still own Vicks Vaporeum, just to make that clear.
Yes, that is correct.
This is a social media ad for Vicks Vaporeum, correct?
Yes, I believe it is.
It says here that you advertise different candy flavors, correct?
Yes.
It says vape the rainbow in bright colors, right?
Yes, it does.
You'll agree with me that the slogan "Vape the Rainbow" sounds like "Taste the Rainbow," right?
Sure.
Are you aware that "Taste the Rainbow" is the slogan to a candy brand called Skittles?
No, I'm not aware of that.
You'll agree with me that "Vape the Rainbow" sounds like "Taste the Rainbow," right?
Objection, Your Honor. Asked and answered.
Your Honor,
It's a different question. Objection overruled.
yes, Your Honor. You'll agree with me that nowhere on this ad do you state the legal age limit to buy this product.
No, not on this ad. We are not required to.
This doesn't state any of the health risks of purchasing this product, right?
Listen, I don't create the ad, I don't place them, and I don't have the authority to remove them. But these warnings.
I want to be
Sorry?
clear. I want to be clear. This ad says Vicks Vaporium, right?
Yes, but as I said, I did sell my rights. Maurice Phillip creates all the ads, they publish them however they want. I don't have the authority to create these ads.
Ms. Vaybrick, Maurice Philippe owns the rights of eVape, the vape product. You will agree with me that you still own the rights to the store Vicks Vaporium.
I would agree, and they get to use my name on their advertisements. This advertisement is not made by me.
If that's a yes, you still own the rights to Vicks Vaporium, right?
Yes, I own the rights to my store.
And you'll agree with me that nowhere on this ad does it state the health risks of purchasing this product.
No, but it is important to remember that you cannot purchase a product from this ad. You would have to take additional steps in order to purchase the products, where then you would see warnings.
That's a yes to my question.
Yes, there are no health warnings on this ad.
Thank you, Ms. Vaybrick. Thank you, Your Honor. I have no further questions for this witness.
Very good. Redirect, Ms. Rapping.
Yes, Your Honor. Ms. Vaybrick, on cross-examination, opposing counsel asked you about a previous situation in 2019 where you were cited for selling to minors. Could you please explain what happened?
Yes. An employee of mine was selling illegal drugs and tobacco under the counter to minors. You know, I am the owner of Vicks Vaporium. The buck stops with me. So I pled guilty as a business decision. I paid my fines, I did my community service, and my clerk is no longer with us.
Ms. Vaybrick, were you ever cited for selling to minors before this incident?
No.
Were you ever cited for selling to minors after this incident?
No.
Ms. Vaybrick, were you ever cited for selling to minor Logan Carter?
Never.
Thank you. No further questions, Your Honor.
All right, thank you, Ms. Rapping. The defense may call its next witness.
Your Honor, at this time, the defense rests its case in chief.
All right, we shall hear closing arguments. Plaintiff, Ms. Gottschall, you may proceed.
Yes, Your Honor. May it please the court. Profits over people. You learned what was most important to the defendant. You learned that the defendant didn't care when minors kept showing up to the vape shop to buy products, so long as they kept lining their pockets. Profits over people. And this is why, as the plaintiff, we brought claims of negligence and negligence per se against the defendant, Vicks Vaporium. That means we hold the burden of proof in court today. We have to prove to you the 4 elements of negligence. 1, that the defendant had a duty of care in reasonably making sure only legal adults shopped at their store. 2, that they breached this duty. 3, that the actions of the defendant caused Logan Carter's death. And 4, that the Carter family suffered damages. We also had to prove to you that the defendant violated a public safety statute by selling products to minors, and that this caused Logan Carter's death. And we had to prove these elements of negligence and like negligence per se by a preponderance of the evidence, simply meaning more likely than not. And we've met that burden of proof in court today, because the evidence has showed you that the defendant put their profits over people like Logan Carter. Let's talk about how the defendant attracted minors to their store. You heard from Ms. Vaybrick that she hosts cloud watching events at her store, Vicks Vaporium. These are events in which adults vape in large amounts for entertainment. Members of the jury, you learned that minors are allowed to be present at these events. You learned that Logan Carter was allowed to watch more than one of these events because the defendant put their profits over people. You saw that on social media, the defendant was advertising vape flavors that tasted like candy. You heard from the perspective of a teenager, Devin Andrews, that as a kid, these advertisements made vaping sound cool, fun, like it wasn't that bad for you. These ads didn't list the health risks of vaping, and they didn't say the legal age limit to buy those products. The defendant let their products be advertised to appeal to minors because they put profits over people. Let's talk about how Logan Carter was allowed to purchase products from Vicks Vaporium. You heard from Devin Andrews that when Logan Carter walked into Vicks Vaporium with a fake ID, the employees didn't even give it a second glance. Ms. Vaber told you on the stand today that Vicks Vaporium has been caught multiple times selling products to customers with fake IDs, including minors. Logan Carter was allowed to purchase product after product from Vicks Vaporium, and their employees did nothing to stop it. You heard from Ms. Womack that the vape pen she found in Logan Carter's room was traced to being purchased from Vicks Vaporium. Vicks Vaporium allowed Logan Carter to purchase these products because they put their profits over people. Let's talk about how the actions of the defendant caused Logan Carter's death. You heard from Dr. Robinson today. He told you that the toxic chemicals in Logan Carter's system when he died caused him to develop a fatal lung condition called popcorn, caused by chemicals used in vape products. You learned that the damage to his organs caused an asthma attack that triggered a heart attack, causing his death. You heard from Logan Carter's mother, Tristan Carter. You heard that on March 19, 2020, she found her 15-year-old son unconscious, unresponsive, and unable to breathe. A few moments later, he was dead. Logan Carter was allowed to develop a fatal lung condition because the defendant put their profits over people. We ask that you find the defendant liable. Thank you.
All right, thank you, Ms. Goodchow. All right, Ms. Rapping.
Yes, Your Honor. May it please the court. Members of the jury, today we are here for the truth. The Carters deserve to hear the truth. And the truth is that Logan Carter knew vaping was illegal, addictive, and dangerous. The truth is that Logan Carter felt the effects of vaping when he laid in a hospital bed for 3 days. The truth is that Logan Carter knew the risks. He felt the risks, but he ignored the risks. Now today, the plaintiff tried to blame Vicks Vaporium, but they failed to meet their burden. They failed to prove that Vicks Vaporium breached their duty to not knowingly sell to minors. And because of that, they failed to prove that Vicks Vaporium caused Logan Carter's death. Now, members of the jury, today, they tried to tell you that it was Vicks Vaporium that got Logan Carter hooked. But you heard that Logan Carter started vaping years before in 8th grade. They failed to prove that an e-vape sold by Vicks Vaporium is the e-vape that Logan Carter used that killed him. Members of the jury, for all we know, Logan Carter used the e-vape that 18-year-olds bought on his behalf. Or the e-vape that his friends let him use in the times they used it between class at school. Or the e-vape that his friend Ty Hamilton let him try in 8th grade. If anyone other than Logan Carter purchased the vape that he used, Vicks Vaporium cannot be found liable. And they failed to prove that Vicks Vaporium sold to Logan Carter knowing he was a minor. Vicks Vaporium sold to the 18-year-old that was presented on the ID. Logan Carter actively deceived the clerks with what Devin Andrews told you had to be a passable fake ID. They didn't know, so you can't hold them liable. Now, members of the jury, even if you believe that Logan Carter purchased the e-vape you saw today in court, there was no evidence that Logan Carter used this vape, no evidence that there was vape liquid inside of this vape, no evidence that this e-vape was the one that killed him. So you can't find Vicks Vaporium liable. Now, in order for the plaintiff to meet their burden, you have to believe that any person in Vicky Vavrick's position could have foreseen Logan Carter's death. But members of the jury, how could Vicks Vaporium possibly foresee the death of the 18-year-old on the ID they were presented? How could Vicks Vaporium know that Logan Carter was actually a 15-year-old who vaped so excessively that his body could no longer take it? They couldn't. So you can't find them liable. Now, members of the jury, what happened to Logan Carter was a tragedy. And the fact that Logan Carter did it to himself doesn't change that fact. But it changes who has to be held responsible. Logan Carter vaped. And in Georgia, we have a rule called assumption of the risks. Logan Carter engaged in an activity that its danger was so obvious that he failed to act with ordinary care. Members of the jury, there's no question that Logan Carter knew and felt the risks. The obvious danger was nicotine. And after spending 3 days laying in a hospital bed, Logan Carter used that vape so excessively, despite knowing that it was dangerous, despite knowing the effect it did on his lungs, despite knowing its addictive properties. Remember that neither Logan's mother, best friend, nor trusted cousin could tell you about any symptoms until March of 2020. March of 2020, as Dr. Robinson told you, when Logan Carter vaped for hours a day. He had no symptoms until then. Logan Carter chose to put the e-vape to his mouth. He chose to continue despite the risks. And members of the jury, as you heard, there were no profits made off of Logan Carter. No profits over people. Logan Carter knew the risks. He felt the risks, but he ignored those risks. So we ask that you find Vicks Vaporium not liable. Thank you.
Thank you, Ms. Rapping. Ms. Scotticho, you have saved 1 minute. You may proceed.
Yes, Your Honor. Members of the jury, Ms. Rapping got up here and told you, how could the employees at Vicks Vaporium have known that Logan Carter was a minor? Members of the jury, you learned in court today that Vicks Vaporium had a routine practice of not thoroughly checking the IDs of their customers. We've shown by a preponderance of the evidence that they've breached their duty because they have not taken ordinary care to make sure that they were selling their products to legal adults. The defense expects you to believe that the employees of Vicks Vaporium couldn't have foreseen that a 15-year-old with a fake ID that cost $15 could have passed as an adult. You learned in court today the numerous times Vicks Vaporium has sold to customers with fake IDs. You learned that the vape pen found in Logan Carter's room was purchased at Vicks Vaporium. And Devin Andrews told you that they bought all of their products from Vicks Vaporium using fake IDs. We've met our burden of proof in court today. We ask that you find the defendant liable. Thank you.
Thank you, Ms. Scotticho. I will now constructively read the charge to the jury. The case is submitted to the jury, and I think it's time we give these championship teams a well-deserved round of applause. All right, it's time for I would like to thank my evaluators my colleagues, the evaluators, for their attention. Mr. Nixon has texted me to remind you that you need to go to rejoin the breakout room, to go back to the jury room to work on your evaluations, and then he'll send you back to us once you're done. So thank you very much. All right. Oh, excuse me, before you go, I hope they haven't all gone, because I forgot to ask the participants to reintroduce themselves. Plaintiffs, please go ahead.
Yes, Your Honor. Good afternoon. My name is Fermeli Gattaccio, and I, along with my co-counsel, Joshua Joseph,
Good afternoon, Your Honor.
and Alia Corey,
Good afternoon, Your Honor.
represented the plaintiff in today's case, Tristan Carter. Would you like our witnesses to introduce themselves as well?
If you please.
Good afternoon. My name is Isabella Dietrich, and I was Tristan Carter.
Good afternoon. My name is Ladau Gavalda, and I was Devin Andrews.
Good afternoon. My name is Colin Crawford, and I was Dr. Bill Robinson.
Thank you. Defense?
Good afternoon, Your Honor, members of the jury. I'm Ellie Weiner, and I conducted the direct examination of Kennedy Womack, the cross-examination of Devin Andrews, and I also delivered opening statements on behalf of the defense.
Your Honor, members of the jury, good afternoon. I'm Andre Mayette, and I conducted the direct examination of Joseph Camille and the cross-examination of Tristan Carter.
Good afternoon, Your Honor, members of the jury. I'm Malia Rapping, and I conducted the direct examination of Vicky Babrick, the cross-examination of Dr. Bill Robinson, and I also made the closing argument on behalf of the defendant, Vix Vaporium.
Your Honor, members of the jury, good afternoon again. My name is Cameron Hardy, and I was Kennedy Womack in today's round.
Your Honor, members of the jury, good afternoon. My name is Jonas Lösel, and I was Joseph Camille.
Good afternoon, Your Honor, members of the jury. My name is Alana Edwards, and I was Vicky Babrick.
All right. Now, my colleagues of the evaluator, it's time for you to go to the breakout room. And all right, timekeepers, are there any time discrepancies?
No, Your Honor.
No, Your Honor.
Good. All right. Any material rules violations I need to deal with?
The plaintiff doesn't have any material rules violations, Your Honor.
None from Your Honor.
Very good. All right. I believe that does it. So we will now be in recess while the evaluators do the heavy lifting. And I'll rejoin you all in a few.
Covers it. Congratulations to getting to this point so far. And I am just always blown away by the hard work that you all demonstrate. So thanks for everything. And we look forward to keeping the competition going in the future. Hopefully in person, but we'll figure it out.
Hopefully in person. All right. So the moment that everyone here has been waiting for. First up is our outstanding awards for the final round. So the outstanding attorney award for the final round goes to Aaliyah Rapping from Grady High School. Good job, Aaliyah.
Thank you.
The outstanding witness award for the final round goes to Alana Edwards from Grady. Congratulations. Good job.
Thank you. Thank you.
And the winner of the 2021 state championship representing Georgia at nationals is the team from Grady High School. Congratulations, guys. Good job. Coaches, we will have the score sheets and comments in the team folders on Google here in the next 30 minutes or so. So congratulations to everybody and good job with everything. So AIS, you guys did a fantastic job this year as well. This is not to take anything away from the efforts that you guys put in. This was really one of the first rounds I got to watch kind of in full, and I was impressed by both sides with it all. So both teams were fantastic with it. I know the judging panel hated their job of trying to figure out the scores and the outstandings and everything. So it was a close round, but by ballots. And so good job to both sides. Congratulations, Grady. And I will see Grady soon to talk about the nationals in Evansville virtually and go from there. So thank you, judging panel, for all 248 rounds that you all put in. throughout this season. These 19 people put in 248 rounds of competition to get us here. So thank you all for your time for the season and for everything that you have done. So thank you all. Enjoy the rest of your Sunday. And again, congratulations, Grady.
Thank you so much.
Congratulations.
Thank you so much.
Congratulations.